I am mentioning item number 48 and 53. This particular revision application is not maintainable before this all will go. I want to withdraw this appeal and I have to pursue the remedy that has been. Well, this is a suit
48 and 53.
53, my lord. My lord, this is a suit proceeding under the Preemption Act. My lord, there was an appeal before the district judge, and the appeal before the district judge is not maintainable. An application for injunction was filed. The court said, in view of section 121, sub-rule 2, my lord, it exceeds the valuation of 1,50,000. We have to approach the. That is the reason, my lord, the court said that the district has no value. Well, this is not section 8 suit. This is a suit under the modern law. Therefore, my lord, I have to withdraw it and I have to file an appeal before the regular appeal before this court. That
53. And what is the other matter? 48?
48.
40, both same.
Two preemption cases.
Two preemption cases. 48 and 53. দুটো একটা দশে রেখে দিন।
Lord, may I, Lord, have your lordship's kind leave, Lord, to mention, Lord, to obtain a leave of your lordship to file without certified copy, Lord, and to, Lord, move on an urgent basis.
What
Lord,
is
the
the
issue is
urgency?
with respect to, Lord, a commercial order 37 suit filed in a commercial division. Lord, admittedly, Lord, the payments have not been done for work order, Lord, completed and done. Now, Lord, we have moved, Lord, through striking out their right to file defense.
What is the urgency?
Lord, the
File it will appear.
Lord, the urgency is, Lord, instead of, Lord, allowing that application, the court has directed me to deposit, Lord, 25,000 with a special officer who will take hold of, Lord, get hold of that, Lord, admitted amount of money.
By
Tomorrow is the date fixed.
All right, file it. It will appear tomorrow.
I'm great.
Have you annexed the server copy?
Lord, may I have permission to mention? Lord, to file, Lord, with the certified copy, but Lord, it is handwritten, Lord, copy. Lord, departments are not taking handwritten, Lord. There are kindly grants me the leave.
Lord, may I have your lordship's
Only may I pray additionally, Lord.
It's the certified copy, but
It is a certified copy, but handwritten.
is it legible, Mr.
Legible,
Chatterjee?
Lord, I am getting it typed also from outside, but Lord, it will take time, so I am taking the leave to file. Lord, I get it typed out.
Leave to file.
And Lord, some urgency in the matter, Lord, stay.
File it, it will appear.
Lord, may I have your lordship's leave to
Within
mention?
48 hours, let it appear. Lord, not so urgent tomorrow, but at department is taking 4 days time to give the
Give
number.
one day more, Mr. Chatterjee, nothing will happen.
Municipality without any, my municipality has passed an order of demolition. My lord, against that, I preferred a statutory appeal. On the 8th, my injunction has been refused. My lord, on 15th, my lord, they are going to demolish. My lord, the certified copy is there. My lord, kindly let it appear on some day before 15th. My lord,
File it, it will appear.
my lord, may I supply the number your to your
Yes,
lordship
yes,
tomorrow?
yes.
My lord, would kindly give.
You mention the date in the presentation form, it will
My
appear.
lord, kindly give some precedence. My lord, 15th is the last date. My lord, they will demolish.
Mr. Banerjee, please mention, then.
Sir, bolun aapni bolun.
Yes.
A transfer petition, and it is running in the list of your lordship on as item number 214.
214.
Yes. Lordship, the matter is
214 ka supplementary list or the combined list? Combined list is section 24.
Yes.
Section 24 order record করে দিন। Order একটা record করে দিন। $43.
My lord. If not taken today, in that event, my lord, tomorrow is the date fixed for
Let
argument.
me see how far I can proceed.
My lord, may I come back at my lord, 1?
Somnath Banerjee.
May I come back at 1 p.m. My lord?
You have 3:30 today.
No, that don't.
Come at 4:25.
My lord, if not in that event, my lord, prior to
Come at 4:25. That is what I.
my lord,
May I permit to,
Come at 4:20.
may I permit to mention, my lord, 100, my lord, item number, my lord, 281. That matter, my lord, the last, my lord, 18, my lord, 8, my lord, I mentioned, my lord. Your lordship take up
You have
one.
mentioned. Don't mention.
No, no, no. 1 PM, your lordship taken up the matter, my lord. The Dhiraj with the appear, my lord, says, my lord, the note service was, no notice was served. Your lordship directed to bring the affidavit of service, my lord. They have.
Alright, when it will be called off?
Model expired on the 88th, my lord. 88th model expired, my lord.
Not now, yes.
Model expired, my lord. Otherwise, my lord, they will
It
process.
has expired, nothing will happen.
Eight, my lord. Already expired, my lord.
24, my lord.
Already expired, my lord. Your lordship take up any day, my lord.
You have mentioned, I will consider. Yes,
Section 24 running in the monthly, letter number
My lord.
please.
295 monthly.
295 for want of determination. Let the matter go out of the
Same
list.
pair 123 of the daily list.
123 daily list, same order for
to move this application, my lord, tomorrow at 10:30, my lord. There is urgency in this matters, my lord. The order 6 rule 17 bill, this is not an amendment of the
please
proceeding.
file the application, mention the date, it will appear.
My lord, may I be permitted?
Item number 956 of the monthly list, my lord.
Item number,
956 of the monthly
what do
list.
you want?
My lord, this is for expeditious disposal, my lord. A matrimonial suit
Don't
that is
mention
pending
today.
since 2009, my lord.
My lord, may I,
Mention tomorrow.
my lord, may I be permitted to mention upon very compelling
What do you want?
This is surface matter.
Wait till tomorrow.
My lord, kindly.
Call the list.
My lord, my lord, there is a order of honorable DR80, DR80.
It will happen, please mention tomorrow. Yes, call the list.
I am for the petitioner, my lord. 24, my lord.
Section 24, same order for want of determination, let the matter go out of the list.
Two, same, my lord.
Same order,
Three,
section 24. Section 24, same order,
four,
section 24, same order,
Hey, mother, naam ta
five,
I appear on the other.
section 24.
Malad, this is a rejection of order 6, my lord. rule
Item
7.
number 10 also.
Why it is appearing under the heading to be mentioned?
So, my lords, I don't know, my lord, my junior has mentioned this matter.
Why? Why your junior has mentioned?
My lord, sorry, my lord, I cannot. কি জন্য মেনশন করেছিল তুমি মেনশন কেন এসেছিল
দাদা
কেন তুমি মেনশন করেছিল কেন মেনশন করেছিল কেন আমি তো জানি The amendment page, my lord, 33,
Yes,
33. So only,
33.
my lord, this the amendment portion is the, my lord's written statement following the words to be added. The dependent number force has 21 decimal land in the suit plot after receiving the summons of the landlord present.
why at this stage?
My lord, this at
After the commencement of trial, nothing. Ashud, this application under
My lord, it is section 24 application.
For want of determination.
Same.
7, same order.
8.
8, same order. Section 24 তো দেখে নিন। Next.
9.
এইট কি করে সেকশন 24 হবে? দেখি 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 দেখি। And others রয়েছে। ঠিক আছে, সেম। দেখি 9টা দেখি, 9 দেখলেন তো? Same order. Next.
10.
My lord, application under section 24, my lord.
Same order. Next.
11.
My lord, I am for the petitioner, my lord.
Section 24.
My lord, not my lord. This is not section 24. This is my lord impugned order against the order passed under order 21, rule 97 to 101, my lord. That is, my lord, inadvertently filed, my lord. This is appealable order, my lord. And for that,
Inadvertently or purposely?
not purposely, my lord. Inadvertently.
Your lordship has an occasion, my lord, to deal with.
Inadvertently or
Not
purposely?
inadvertently, my lord. This is inadvertently.
My
not
only,
purposely.
my lord, my only contention, my lord, no liberty should be granted, my lord,
My
here,
lord, this
but
is-
I will take all
All right,
points.
proceed with the order 21 notice. I'm taking it on merits. Yes. 227 white power, court can take up. Even if
Yes, my lord.
there is an
But I-
existence of an alternative remedy,
Or my lord,
227 can be entertained.
My lord.
Yes, please move.
my lord, I was apprehensive about this thing, my lord, only prayer, my lord, to
You have filed the application. I'm entertaining your player.
will, in that event, my lord, I shall pray for one day accommodation, my lord, because I'm not prepared, my lord, to move this matter, my lord. I should be candid with you, lord.
You're not prepared. Who has filed this application?
My lord,
You are not the advocate on record.
no, my lord.
You have drafted the petition. At that
My
time,
lord knows everything, my lord.
I do not know anything. How do I know who has drafted the petition?
Well, I may be excused, but 7, 8, 9 was my matter. I was just.
Section 24. It has been released. I do not have determination, section 24. Yes, next.
And run for the preservation. This for correction, Your Lordship.
Yes.
Your Lordship, the first two paragraphs should be deleted from the order dated 11th March of 2025.
Why?
A series of matter, Your Lordship, was filed, and in the
Here there is no mistake.
no, Your Lordship, in CO 471, those two paragraphs were there, but
472.
no, liberty.
No, amendment of the court title.
No. Only in 471, the amendment was done. And my lord, in the third paragraph, miss appeal would be 19 of 2018 instead of
right.
21 of 2018.
In this matter, your lordship called for a report from the learned district judge Alipur and also the trial court with regard to what is that order they are requiring. The suit was for ex parte hearing. And then all of a sudden, this order is awaiting order from the learned district regarding jurisdictional transfer of record.
You are for the plaintiff.
Yes.
So you filed an application for transfer. Your client filed an application for transfer.
No, I did not file.
Yes.
No.
One senior learned advocate, namely Bandana Chowdhury, appeared for the plaintiff without filing any vakalatnama and submitted that she would file a petition under section 24 of the CPC for transfer of the record on the point of jurisdiction. Bandana Chowdhury is your advocate.
Suit file without suit file বলেছে suit file suit file without vakalatnama. It was fixed for ex parte hearing.
But I do not know this application, but this is the report. Please take instructions from your client.
Then kindly fix it up next week. I will come up with that.
But no application was filed.
স্যুট ফাইল এসএজি ওইএলডি স্যুট ফাইল বলছে স্যুট মানে ফাইল করবে বলছে সেটাই রিপোর্ট
জন্য সেকশন
সেকশন 4 এর জন্য ফাইল করবে বলেছে অ্যাডভোকেট কিন্তু করেনি তো বলছে
will file.
হ্যাঁ
Your lordship, it's not been filed.
But you have said that on that ground it was adjourned. Please take instructions.
I'll take
He is your learned advocate on record. He has to clarify that he does not want to file any application.
I want to see the transfer. There is no application for that. That
But you have some advocate, it must be entrusted by the plaintiff. Otherwise, no advocate will appear saying that I will file.
Wakalat number also, your lordship.
Maybe at times it happens, some oral instructions, lawyer comes, we also accept their prayer, give them liberty to file vakalatnama subsequently. We also grant leave.
I'll take instruction.
Please take instructions.
Come back next week.
Yes, next.
My lord, I'm for petition.
Yes.
My lord, only one correction would be there. In the first page, third paragraph, instead of 7th March 2021, it will be 7th March 2025.
7th March
2021 is there. It will be 2025 at the third paragraph.
All right. It has been submitted by the learned.
My lord, 15, my lord, it has come up at the instance of Mr. Odhikari, my lord. My lord, I would beseech my lord to, my lord, may hear this matter today itself, if subject to my lord's convenience.
Any day may be fixed for hearing, my lord. I am ready,
Because
my lord.
hearing was almost
Tomorrow.
completed.
Tomorrow.
Tomorrow I am fixing.
My lord.
How much time you will take, Mr. Odhikari? He has
Lord,
completed.
My lord, only his point is that means that this court has got no jurisdiction because there is.
So you will cite decisions in that regard.
My lord, that is what I am to say, my lord. That means that only that means that this court has got jurisdiction not only, but if there is, that means that there is grave injustice.
How much time you will
My lord,
take?
maximum 30 minutes, my lord, if within
30 minutes.
my lord, within 5 to 10 minutes, or my lord, that the maximum 30 minutes, my lord, if he is not agreeing with me, because there is fraud. By my lord.
Mr. Odhikari, he will not agree with you. Cannot, because Mr. Odhikari, he is
interest.
He is a creature of instruction.
My lord.
So he has to make
Yes.
up his point. He will neither he will agree to his point, he will also not agree to
My
your
lord,
point.
the law is always in my favor, and your lordship.
So he has made his submission saying that the revision is not maintainable. You make your submission that the revision is maintainable.
My lord,
He will not agree.
are here.
Neither he will agree to your point, nor he will agree
And
to his
your
point.
lordship is the next to God.
No.
Next to God.
No. So tomorrow 4:15.
Tomorrow 4:15.
15, 1-5.
1-5, my lord. At least 4. At least 4. At least 4. At least 4, my lord. I think because, my lord, that this is such a matter, my lord, where I want to expose yourself, my lord, that expose myself before your lordship. That means that.
All right, 4 p.m. Kalke 4 p.m. Fixed matter করে দেবেন, under the head
Your
of
Lordship.
fixed matter.
Your Lordship, I am praying for a week's accommodation as the learned counsel appealing for the petitioner is suffering from ailments. He is under fever.
Yes, yes.
I am not being engaged in this matter. I am praying for just a week's accommodation as the learned counsel is suffering from ailments. He is under fever 102 degrees Fahrenheit.
Wrong submission was made by him.
I am
You know that. You know that.
under the instruction of the
Yes, yes. That is why I've kept it.
I am not being aware, Your Lordship. I am not being aware.
When he will be available?
I am not being engaged in this matter also.
When he will be available? You have asked for time. I'm accepting your prayer. So you must be having instructions or take instructions and then come when he will be available. This is not done.
Apologize.
The orders are passed relying on the submissions of a learned advocate. Please take instructions when he will be available. Then on that date, this matter will be kept.
Your Lordship, kindly.
I'm passing it over. Please take instructions and come.
Yes, Your Lordship, kindly for not today. I will
Not today. You can contact over telephone. Please contact, then make submissions.
Your Lordship, I'm much apologize for that. Your Lordship, kindly.
And he can also appear virtually.
I will convey that. I will
He
convey.
can also appear virtually for this purpose.
Your Lordship, kindly.
Please take instructions. I'm passing it over. I'm not making it not today. Yes. Pass over. Next.
17.
Yes, Mr. Shah. এটা রাখুন, pass over.
Lordship, against the amendment of plaint, I have come here. Lordship knows the Lordship are very liberal regarding, but in this matter, the total facts, total case will be.
You are for the defendant.
I am for the defendant.
Amendment has been allowed.
Allowed.
You file your additional written statement, Mr. Sahu.
That I know. I know Lordship are very liberal, but here in this case, Lordship, the plaintiff has no right title interest.
That will be decided in the suit, Mr. Sahu. That will be decided in the suit.
That is what, why Lordship, a defendant will contest who has no right title interest. Suit has been filed 2012, amendment filed 2023. Even he knows that he has no right title interest.
No, at what stage? Trial has commenced.
I think these amendment application
Trial has commenced.
After written statement, this application has been.
Yes, but trial has not yet commenced.
That is, I
So
know.
pre-trial amendment is much more liberal.
Lordship kindly see the schedule of the amendment. This page, amendment application 47, Lordship kindly come. Entire 3-page amendment plaint and 3-page extra schedule of the plaint, amendment plaint. Lordship kindly come, the 47 is the amended application and schedule is start from 49. Lordship kindly entire case has been changed. And who is now the owner? He is not a party.
That is, all points will be there. You can take all those points.
Let them file a fair suit. You enter.
Multiplicity of proceedings.
That is not what Lordship.
If he is entitled to file a fresh suit, Mr. Sahu, so to prevent multiplicity.
Yeah, Lordship, one thing, Lordship, very reasonable requirement plain ground is there.
Give me a minute. Let me go through the order. What is your submission that the averments which have been sought to be incorporated are not true?
Not true. All false? Total case is will be changed, not false. Total case will be. He has filed a suit.
What is the suit for?
No, suit for eviction.
Suit for eviction. And by allowing the proposed amendment, it has been converted to what type of suit?
That is also reasonable requirement. One is reasonable requirement, but the the peasant owner of this is not the party. His son only his
take that
father was
point.
so angry with him.
You take that point. So the
That
suit
will
will
be
be
clumsy.
suit will be dismissed on the ground of non-joinder of a necessary party.
No,
That point is.
that time again they will come for a addition of party. The original
They will come with that. Then I will.
The entire the amendment has been made. That will be changed by the schedule. Entire amendment. You kindly see the second paragraph schedule of the second paragraph. Page 3. It will be tested. First should file intestate on the ground of intestate. It is tested. He has no locus standi. His father was angry. He has cancelled the first will and second will made. And
that is on the merits.
It is on the merit. I know, Lordship, but it is tested, intested. Then, Lordship, and the inducted his son. Lordship, only the third paragraph, Lordship. It is not a single word in the original print. Entire case will be changed. And that will be clumsy. Case will not, Lordship. Written statement is another form. Then the additional is another total clumsiness. Let them file a suit. That is reasonable requirement. The owner will add it 3 years time. Total case will be changed. That will be clumsy. Let them file and Lordship pass an order, expeditious hearing. I have no objection. But case should be fair and easy and fair. Reasonable requirement, original order has not passed anywhere, yet not coming with a reasonable requirement. Original order. He has no right. Plaintiff has no right.
You have purchased the flat, Mr. Shaw. Your client has purchased the flat.
No, my client is not. My daughter, married daughter has purchased. That is another thing. My married daughter. That I have also. My married daughter has purchased. Let the file is full also.
This application.
internal page 4, internal page 3. The court is not inclined to be hyper technical.
Thereafter, you prefer a miscellaneous appeal.
Against the order of this miss case. No, my lord.
It's an appellable order, Mr. Ghosh.
But it's
Order 9,
section
Rule
5
9,
Section 5 application.
Section 5 along with the miscellaneous case.
But
Earlier,
if I can see-
76 Calcutta has been overruled, Mr. Ghosh.
Yes, yes, my lord, if your lordship kindly see the order in portion, may I read for your lordship? As a result, the court is inclined to reject the petition under section 5 of the Indian Limitation Act.
Thereafter,
And in turn, the court is also recorded an order dismissal of
that was the decision, Mr. Ghosh, of the 76 Calcutta full
the
bench.
consequential that miss case dismissed.
That is the decision of 76 Calcutta for which it was held. Rejection of section 5 is revisable. That has been overruled in 2005, Pannalal Jaiswal.
Pannalal Jaiswal.
You know that, even then you have filed this after some argument. Yes.
Wait, please, Your Lordship. Lordship, this petitioner preferred this revision application, my lord, being agreed by the order of rejection of a petition dated 19th September, my lord, where the petitioner father, my lord, prayed for an file an application praying for a direction to allow his minor child to, my lord, visit the house of the petitioner so that he can, my lord, spend some time with her grandparents, my lord, paternal grandparents. That has been rejected, my lord. My lord, the order impugned, my lord, is ordered at 21st of February on the next portion, my lord. My,
Previous applications were rejected. You have not challenged those orders.
my lord, previous applications,
21st of May 2022, 17th of September 2022. Where are those orders?
my lord, those orders has that has been by virtue of that order, my lord, this petitioner father was granted visitation right over telephone.
Show me those orders.
My lord, those order has not been annexed, my lord. If your lordship can grant me a leave, my lord, I'll, my lord, take the certificate copy and, my lord, annex those orders, my lord.
On the prayer of the learned advocate for the petition.
A person who is not in possession filed a suit inter alia seeking for permanent injunction and confirmation of his possession. Suit decreed ex parte. Filed an application for execution in the tabular statement, confirmation of possession and restraining me from disturbing his possession. But in the execution case, he filed an application for recovery of possession. I shall show, but for the time being, for the purpose of deciding the order impugned, your lordship need not go into that.
What is the order impugned?
The order impugned is the last order your lordship takes up. He takes 19th February your lordship need not go into the entirety, because what happened, he said some muds, heap of muds and construction materials are there in the suit property. I am not removing it.
Mr. Mukherjee, this matter was considered earlier by any court.
This matter, but I am.
Why the certified copy has been marked? Dinto? Dekhan.
Certified copy to mark. So it's my mistake. It's my mistake.
Coming from your share,
It should not have been. It should not have been. But I should be more careful, prior to filing. I have missed it. I have missed it. But kindly excuse me. May I erase it, and it's my mistake. He applied that some heap of muds and building materials are there.
That is a tabular statement.
Yes, tabular statement, your lordship will
By
get.
this order, what has been done?
By this order, the learned judge directed me to immediately remove those material by 14 days or 15 days. In default, 50,000 to be deposited as cost. There are further.
Where is the decree? Where is the decree?
Decree, your lordship will get, page 19, operating portion. 18 it starts, 19, the judgment operating portion. That the plaintiff have, it's decreed ex parte, plaintiff have right, title, interest and possession over the suit property, recording in RSR present LRR.
Challenge this decree? No.
No, I have not. So that's why the tabular statement is at page 24, apropos to the decree, my lord.
So tabular statement, tabular statement, there is no defect.
No defect. Page 29, lordship once looks at.
What is 29?
29, the decree holder filed an application before the executing court seeking decreedarke বাঁশগাড়ি মতে দখল দিতে কোনো বাধা নেই. Since there is no appeal pending against the ex parte judgment, he asked the executing court for the purpose of taking over possession in respect of the suit property. Just to show before your lordship, a person not in possession is seeking by virtue of this execution recovery of possession. Now, after we have objected to this, they filed an application under Order 39 Rule 7 seeking for local inspection. Local inspection held, report submitted that yes, certain construction material and certain heap of muds are stacked in the suit property. They filed an application for removal of all those things. By the order impugned, if your lordship now takes up, learned judge is directing, kindly takes up the ordering portion. I am aggrieved by the second part because I have already removed within the time. Filed the compliance.
You have removed.
Kindly see, first the executing court is directing me to within 15 days to remove it.
Where, which paragraph?
Ordering portion, second paragraph, may I show?
Ordering.
Last portion of, last page of the order impugned.
Yes.
Judgment debtor are hereby directed to remove the articles such as heap of cow dung and stone chips, such and such material of the judgment debtor from the suit property at their own cost within 15 days from the date of this order. Kindly now thereafter. In default of which, judgment debtor shall pay compensation 50,000 to the decree holder within 15 days by way of civil deposit challan to the decree holders. Next in default. Next in default, in further default of which, the immovable property of the judgment debtor are liable to be attached and sold for recovery of possession, compensation. The excess shall proceed shall be given back to the judgment debtor. Not pausing here. I have done that 15 days. Compliance report is annexed to the revisional application.
Then you are not aggrieved.
Kindly see the second part. Now, judgment debtor are hereby further directed to file an affidavit of their assets of the immovable property within 15 days from the date of this order. This is mandatory, my lord, again. So that the property may be attached for recovery of compensation.
Mr. Mukherjee, all these are consequential if you do not comply with within 15 days.
No,
according to you, you have complied with.
But the question of the second part, there is no in default.
Mr.
Second part is I have
second part, Mr. Mukherjee follows the first part.
But the learned judge has not made this. Kindly takes up
first part.
But if I do not pay 50,000 compensation plus the attachment of my property, if I do not pay. But second part is from the date of this order. Otherwise, I will be arrested. This your lordship kindly clarify because I have given the compliance report. I have submitted.
All right, Mr. Mukherjee, I am giving you liberty to file an application before the executing court, stating because the executing court has to decide whether you have complied with or not. I am recording your submission.
My compliance is already there. Milord, kindly take up.
Show me
that there is-
the court has recorded that you have complied with.
That has not been taken up.
That is
Page
by
35.
I am directing that application to be taken up.
Only clarify that, Milord, if this has been this compliance report, page 35.
Mr. Mukherjee, it requires no clarification because Mr. Mukherjee, please come to the first part.
Yes.
In default of which the judgment debtor shall pay a compensation.
I'm on.
So that is in default.
Absolutely right.
And
Milord.
to file an affidavit of compliance after complying this order, then a further directed to file an affidavit of absence within 50 days so that the property may be attached in default. So for what?
Kindly see.
For
On the day of this order.
for recovery of the compensation, Mr. Mukherjee, compensation comes if you fail to comply with.
I'm coming. I'm
All right,
coming.
I'm
So
clarifying.
that the property may be
I will
attached
give
for
you.
recovery of compensation. Milord,
That is your application.
Kindly takes up thereafter. If the compensation is found unpaid. Now, in default of filing the
Your
affidavit,
application. Where is your application?
Milord, page 35, Milord, page 35 and 36. Put up petition along with, Milord, the compliance, page 36. Page 37 is the photograph that I have removed.
Page 35.
35 to 37, Milord.
Photograph, Mr.
I'm not-
Mukherjee, nobody knows from where you have taken this photograph.
Apprehension is, Milord, last part. In default of filing affidavit, the judgment debtor shall be detained in civil prison for 1 month.
No, where you have stated that in view of that, compensation should not be page. What is page 38?
Page 38. Milord, page 38, the impugned application by virtue of which they have prayed for removal of those things.
No, this is after your page 35.
After my page 35.
What is the date of page 35?
Page 35 date.
Sorry, page 36.
Page 36, Milord, it's of 4th of March 2025.
And this application of theirs?
This application. Oh, acha. This, sorry, Milord, I'm sorry. Page 38 is the application by virtue of which they have asked for police protection so that no further, Milord, disturbance should be.
That is a different thing altogether.
That is different.
So I'm directing this, but here you have not stated about anything that even then you have been directed to.
No, Milord, I am not on that issue with regard to 50,000, Milord. I am not. But I am on issue, Milord, regarding, Milord, if your Lordship kindly once take the last page of the order impugned once for my satisfaction. May I read with your Lordship, Milord, the last but one paragraph?
Yes, of the impugned order.
Of the impugned order, ordering portion, the second penultimate paragraph, judgment debtor is hereby further directed to file affidavit of their assets within 15 days from the date of this order, so that the said order may be said property may be attached for recovery of compensation. Not up to this, your Lordship is absolutely correct. Now kindly see. If the compensation is found unpaid,
yes.
Now, in default,
sir, in default comes thereafter. No. So if the compensation is found unpaid, then you have to file affidavit of assets.
No, in default of filing of affidavit, kindly, this affidavit is affidavit of assets. The judgment debtor shall be detailed.
Mukherjee, it follows that if you are in default, Mr. Mukherjee, if you are in default, you have to pay compensation. Then for that, you have to file affidavit of assets. So if you do not comply with,
clarify that
you
only
I will directly executing.
Otherwise, Milord, they are taking steps for the purpose of detaining me in civil prison where I have already complied.
21.
Your my lord, I am for the petitioner, my lord. But I am praying for my lord an expeditious disposal of an application, my lord, in a suit of 2024. My lord,
Application, what is the application
yes,
for?
yes, yes, I'll just indicate, my lord. The application is for my lord clarification and doubly or modification of an injunction order which has been, my lord, passed at the ad interim.
3rd of June is for injunction application.
My lord, 2nd of July, the application was filed. My lord, kindly, my lord, let there be a direction, my lord, for my lord, disposal of the injunction application, my lord, as well as this application.
You are
Otherwise,
for the plaintiff.
plaintiff.
Written objection has been filed.
Everything is
This
filed.
application under Article 227 of the Constitution of India is at the instance of the disposed of. PO number such and such disposed of. Yes. Next.
22. This is for expeditious disposal of a suit under section 27 of the Special Marriage Act, my lord.
What is the stage of the suit? Who are you?
I am the petitioner husband, my lord.
Husband, what is the stage of the suit?
Issue framed on 5th February 2024. Thereafter, nothing much.
Any proceedings for alimony pendente lite?
Proceedings are there, but no order passed.
So let that be decided first.
Yeah, that has
That
to,
has
let there be directions for both, my lord. That is.
First,
Let it be decided first, but
because the amount of alimony areas you have to first liquidate, then you can proceed with the.
We are in fact, my lord, both the proceedings.
You pay, you voluntarily pay, come to an arrangement that this much you will pay. Yes, I can direct. Otherwise, not. This application under Article 227 of the Constitution. next.
23, I'm for the petitioner.
Yes, Mr.
These are application for early disposal of the suit. Suit is of 2011. Suit for declaration.
What is the stage of the suit?
Stage of the suit, kindly see the last order, which is at page 29 November. There is a direction for filing WS. 2011 suit, 2024 amended plaint filed on 28 November 2024. We got an injunction order in the year 2012 to that effect, not to transfer the property in any third party. 15 years. Last page 120.
What is the JMS case for? What is the JMS case for, Mr. Chatterjee?
Well, probably, my lord, against the injunction application, they filed the misappeal.
Probably, you do not know. What for?
No. I kindly see the last page order dated 29 November 2024.
Why cost was imposed upon you?
Cost upon imposed, kindly see the order dated page 116, order dated 30th July 2024.
30th July?
30th July 2024. Page 116, I paginated the Xerox copy of the certified copy of the orders.
July 2024.
30th July 2024. This is the order number 114. There is a direction for a filing amended plaint that has not been filed. That's why in the year 2024, 2011.
Yes, so you did not file the amended plaint.
And now we have filed with cost.
So I'm directing not to take into consideration the amended plaint. You have delayed, cost was imposed. This is the delay, Mr. Chatterjee.
That has already been accepted by the landed court below. Now there is a
for saying that you did not pay the cost, you should not be accepted. You have amended the plaint. Even then you have not filed within the time, and now you have come up for expeditious.
We have already filed now. 28 November 2024. This is 15 years now.
So now let them file the additional written statement.
Yes. There is right direction already. Kindly see 28 November 2024. At least a direction upon the landed court to early disposal of the suit.
This application under the additional written statement, issue framing, if done, modified issues, long way to go. Yes, next.
24. Publish.
24. Lord, the case, my lord, this is a preemption suit, my lord, the petitioner before lordships. The order passed, practically order in my favor, some modification is required. My lord, I prayed for 6 quotients. Out of 6 quotients, only 4 quotients has been allowed, 2 quotients has been left out. This is the my grievance only. The MP order kindly see in the first. We have prayed to follow.
Where is your application?
This just before that I have annexed. Just before impugn order. Recalling petition. I mentioned 6 quotients. 4 quotients allowed, but 2 quotients left out. This is only for modification, nothing. And even the impugn order in the bottom portion, kindly appreciate that. This is a submission also advanced. Two-fold prayer only.
Where is your amendment application?
That has been allowed.
Yes, show me the amendment application.
Amendment application.
Yes, by virtue of amendment, 4 quotients were only allowed. So,
but
rightly done.
No, my lord, the recalling petition, my lord, kindly appreciate.
Maybe, but the consideration was that since by way of amendment, these 4 quotients were filed, and on the next date it was fixed for argument, you did not get any opportunity.
That is the reason. I admit to that question, my lord. My lord, only things for a moment. I made the prayer by mistake of 2 quotients.
That was rejected by the
that has not been specific order.
That is
no order.
Show me your application.
Or kindly appreciate the order. Kindly impugn order.
Show me your recalling application. What grounds have been that you have stated?
That is annexer C, my lord. Kindly appreciate.
Yes, page.
Just page just impugn order before just impugn order. The দরখাস্তকারীর পক্ষে তাদের 5-3
page.
Page, my lord. Here is the no pagination. Just impugn before just impugn order. This is the recalling petition. Recalling petition, the bottom portion, Eller quotient number such and such. All the quotient I have mentioned. 4 and 2. Down. Pagination down again. And impugn order it has discussed.
Why these 2 quotients are relevant? Where have you stated that?
In the recalling petition, my lord.
How that is you have stated that those through mistake it was not. How that is relevant for the purpose? Show me your pleadings. From the pleadings, how it is relevant?
Pleadings of the main.
Yes, you are the preemptor.
Yes.
So you want to tender that. Show me from your preemption application why those 2 quotients are relevant for the purpose of proving what case?
Annexer A.
Yes. Show me where have you referred to those Khotians?
Origination ground. ওই প্লটে উল্লেখ করা হয়নি। No, this has not been mentioned.
Even
This
if it is not relevant, why that should be allowed?
But the ordering portion kindly appreciate to that. That
ordering portion is because please come to your application. You have stated that by way of amendment this was allowed, for which page 25 ইংরেজি 26/4/2023 তারিখে সংশোধন দরখাস্ত মঞ্জুর হইবার পর তৎপরিপ্রেক্ষিতে কোনো সাক্ষীর দিন ধার্য না হওয়ায় আটপুকুর মৌজার এলার নাম্বার such and such. So that is your ground, was allowed.
That's true. I admit it. I admit
there is nothing with regard to those two Khotians.
Two Khotians, man.
Then you have said recalling for these 6. That cannot be a ground.
No, recalling of this.
Nothing has been said with regard to.
That was not, my lord, the exact tendered in the CPR cause. That's why prayer for took along with this. And just only prayer for modification to that extent.
By the order impugned.
Lord, yes, my petition. Lord, here is the case, my lord. In one suit, my client is the plaintiff, and the another suit has been filed by the defendant. My respectful submission on the our suit, then an injunction order is there. My lord, the plots are in the same in the suit.
What are the two suits for? What is your suit for?
Yes, madam. That is my suit for declaration and injunction.
Show me your plaint.
Sorry, declaration and permanent injunction. I have annexed the document, annexer plaint, annexer A.
Your suit number is 312 of 2023.
312.
312.
Yes. Well, kindly schedule of the plot, my lord.
And what is the suit filed by the other side?
That I have annexed.
Page.
Only 1 minute. Hold করতে বললাম। আমাদের suit. This is the page 20. No, sorry, page 410. Injunction. Page 34. This is also suit for injunction, suit for declaration, permanent injunction, and the scheduled plot are same. In my case, my lord, the injunction order is there. And kindly schedule plot, inner page 8 of the plaint. But the learned church already holds that both the suit plots are different.
Yes. Two plots are different, rightly held.
This is not the correct.
Yes, yes. Please kindly come to page 41. Their suit is for two plots, 1053 and 1055.
Yes,
It's a more comprehensive suit.
Yes, this is my responsible submission. Alert dark number 1053.
Yes, that is your plot.
Yes.
Kindly come to page 41. Their suit plot is 1053 and 1055.
This is also the relating to the 1053.
Also 1055. So their suit is a more comprehensive suit. So I am staying your suit. I am directing that suit to proceed.
No, my responsible submission.
That is a more comprehensive suit. Area is larger. So if that is decided, so both of you are paying for title in respect of the same plot.
Of course, my case is my case is.
Where are the issues, friend? Have the issues been framed?
The injunction order is there.
Injunction order is neither here nor there.
Neither issue.
So if the issues are not yet framed, where is the question of stay?
No issue at only for filing the written statement, nothing more. Title suit. Issue has not been framed. Order 39.
And this is my application matter. This is my case. My lord, in this matter, my lord, in this, when a suit for declaration of title and injunction was filed against the petitioner defendant number 4, mentioning Pinaki Ranjan Patro, but not Pinaki Patro. I am Pinaki Patro, but not Pinaki Ranjan Patro. My lord, I have stated in paragraph 1. I have stated also paragraph number 2 that on 5/12/23, petitioner defendant number 4 appeared before the learned civil judge by filing
Which
vocal.
order you are challenging?
My lord,
Which order you are challenging?
my lord, order. My lord, page 19. Page 19. My lord, hence, the case is proceeded ex parte against defendant number 3, 5 to 6. My lord, defendant number 3 has already died. My lord, the proceeding has been started on all orders.
You are not the defendant number 3.
My lord,
You are not the defendant number 3.
my lord, defendant number 3.
Are you the defendant number 3?
No.
Then
No, my lord.
you are not concerned with the
My lord,
defendant
he
number
is my
3.
brother. My lord, he is my
If
brother.
your brother canvass your case.
Now,
So
my
you are
lord,
not the defendant number
now,
3.
my lord, very
So let the brothers or
now,
the
my
heirs
lord,
of your brother take steps.
now, my lord, already he has died, my lord. If the suit is running
Yeah.
against the dead person.
Inform the heirs.
And for that reason, my lord, I have filed the application before the learned civil judge. My lord, kindly.
What is the application?
My lord,
What
kindly.
is the order you are challenging? Please show me the order which you are challenging.
My lord, the all orders are not from my lord. He against the dead person order is being passed. My lord, therefore, I have filed application to the before the learned civil judge. And that is pending. My lord, kindly come to page. My lord, kindly come to page. My lord, 16. 16. My lord, it is to be considered. Kindly come to page 16. Brother has died. My lord, very important thing is, my lord, case before starting the case, my lord, the defendant number 3 has died. So, my lord, against a dead person, the case is pending. My lord, already he died. It has been abated, my lord. And that is pending, my lord. For that purpose, I have filed the application, page 16. And it said,
what happened to this application?
Well, nothing. It is to be considered. It is still now pending. And I have mentioned on several times.
You have filed this application when?
My lord, my lord, on 11. My lord, no. My lord, 11/9/24. My lord, kindly come at the bottom, my lord. 11/9/24.
You are which defendant?
My lord.
You are which defendant?
My lord, I am defendant number 3, my lord. My brother is
number 3 is Somnath Patro.
No, Somnath. I am the defendant number 4, my lord.
Pinaki Ranjan Patro.
Yes. He is the elder brother. And younger brother is 3. But he has died. Against the dead person, the case is going on, my lord. Therefore, my prayer is very short. Kindly direct the learned municipal to consider the representation application pending before the learned civil judge. Application dated 11/9/24. My lord, kindly see at the bottom, my lord. Page number 16, Annexure B, my lord. The suit has already been abated, my lord. Paragraph 4, that the suit has already been abated.
Ashun.
তিনজনের নাম কি?
দিদি এটা একটু
Yes, go ahead.
Lordship, item 27, Your Lordship, I am for the petitioner. Lordship, in this matter, Your Lordship, I am challenging an order passed by Your Lordship, the first appellate court, wherein Your Lordship, the appeal as Your Lordship was allowed, and Your Lordship, the order passed by, or rather the decree passed by the first trial court, Your Lordship, has been set aside. May I just state the brief facts what has happened? Lordship, section 72 of the Registration Act, Your Lordship,
how a revision is maintainable?
Lordship, the appellate court, Your Lordship, this is a decree, Your Lordship, finally.
Yes. 227 maintainable.
Lordship, Order 7, Rule 10, Your Lordship, that has been converted into a decree. They preferred an appeal.
Yes.
And then, Your Lordship, a second appeal, Your Lordship.
Know that we have filed 227 application.
So kindly grant me that liberty to, Your Lordship, file it.
The learned
But though not, I'm not in caveat. But
why have you not caveat, Mr. Chatterjee? You have no right of audience then.
but only from the impugn order, I can urge one point that it is not
Let
maintainable.
me see if it is maintainable.
Lordship, I am out.
You do not have any right to oppose the prayer for stay, Mr. Chatterjee. Because you have not lodged any caveat.
Lord, my lord, can
I am aggrieved by an order passed by Learned State Consumer Dispute Redressal Commission.
Give him a copy because he is appearing.
Lord, I can.
Though he has not lodged a caveat.
Yes, I can supply, my lord, but may I just place my case, my lord? The Learned State Commission, my lord, without granting any opportunity of hearing to me, totally allowed the revision petition, my lord, and set aside the order which was challenged in the revision petition, my lord. Now, may I just state the brief fact?
You are
my
not
lord?
given any opportunity of hearing.
Yes, my lord. Even there was a delay. The revision petition was allowed at the stage of admission, my lord. May I just come to the impugned order? No notice was served. I was never called upon to contest, my lord.
for that, my lord, I need a copy. Take instruction. What has happened?
From impugned order itself. May I show from the impugned order itself, my lord?
Give him a copy.
Yes, my lord. I will supply a copy, my lord. I have.
When this
Number 10,
My application.
Yes.
Arising out of an order rejecting my Order 7 Rule 14 application. Suit is for declaration and delivery up and cancellation of a deed of gift purportedly executed by my father. Now, the parties are brothers who have been litigating for several years. Father had 2 sons and 1 daughter. The deed of gift, he has granted a portion of his property in favor of one of his grandsons, who is the son of the defendant brother, completely disinheriting all his other heirs, all his other grandchildren. I have challenged this deed of gift.
What are the documents?
The documents I want to rely upon.
Show me that application.
The application, your lordship will find at page 75 and the schedule is at page 77. Now, my lord, after this, because my lord, I have pleaded it and it is also reflected in the order, my lord, this, the learned judge was pleased to observe, although it is not recorded, that these are vague descriptions. I thereafter filed a supplementary affidavit, page 91, to which they have also filed a written objection, giving better particulars. 91 is my supplementary, and my lord, the schedule to 91 is at page 93. Now, if your lordship sees, my lord, here I've given full particulars. A, B, C, D, E, up to E. Well, these are all, my lord, relating.
In the plaintiff, you have filed a list of documents.
Yes,
no.
I have.
So you have mentioned these documents.
Documents were not there. To be candid, well, these were in existence. Also, I have pleaded in my application. But because there was a change of advocate, this learned advocate, after going through the papers, felt that these documents are necessary. In fact, pleadings to that effect are also there in the plaint. These will show that the father did not have sound mental faculty when he executed this deed of gift. Reason I'll tell your lordship, at the same time, there was another suit, a partition suit, which was also proceeding before the Alipur court. In that suit, he has filed his affidavit in evidence, and he has also gone into the box and deposed. In course of his examination, he was found not completely incoherent. He wasn't able to understand or answer any question, which is why learned judge also asked him to write down the answers in a piece of paper. It is all part of the records in that suit. Even the handwriting, if your lordship will see, it is visibly shaking, and the answers make no sense.
What is the suit for? Where is the plaint?
Delivery and cancellation of a deed of gift. Plaint is at page 15. Reliefs, your lordship will find at page 29 onwards. Prayer is decree for cancellation. B is incidental reliefs. And grounds.
What is the ground on which you have sought for cancellation?
Yes, grounds I have pleaded at paragraph 35.
Tell me what are the grounds?
That he did not have sound mental ability to execute a deed of gift.
So what are the documents which you are now seeking to?
Yes, now if your lordship also takes the trouble of coming to paragraph 23 to 25. Here the ingredients are also pleaded. If I may just quickly place. Plaintiff states that the father, who is the person who is executing the deed of gift, in his affidavit evidence filed in the partition suit, proceeded on the basis that he is one of the co-owners of flat number so and so. And the deed of gift relates to this flat.
What are the documents you are seeking to?
Yes, the documents, I had shown your lordship the schedule at page 93. Some of the documents relate to this other partition suit where he has given evidence after the purported date of the deed of gift saying I'm still the co-owner.
How these documents are relevant in this suit?
Because it will show that even after the deed of gift, he says he is the owner of the property.
Maybe.
And
they are not there.
He's maintaining that.
After that is a different thing altogether. The affidavit in chief of others, the affidavit in chief of other suits.
Yes,
these medical documents that
he is taking a stand completely contradictory to the deed of gift.
Auction notice of DRT, order of.
My lord, kindly sees, just one by one. I'll show your lordship. Affidavit in chief, application in TS so and so, examination and cross-examination. This has all happened after 2017. In 2016, he has gifted away the property allegedly.
Right.
In 2017, he says, I'm still the owner.
Maybe.
And his deposit.
That cannot be a ground for cancellation. Can that be a ground for cancellation?
Even his deposition will show that he is not of sound mind. His mental.
Show me that you have placed reliance on that deposition in the pleadings.
Yes, that is there.
Show me.
Kindly sees paragraph 24.
Yes.
Page 21, internal page 7 of the plaint. Plaintiff further states, father filed his affidavit evidence in the partition suit on 13th February 2017. Thereafter, he is cross-examined on these 3 dates. And his cross-examination remained unconcluded. Copy connection. One of the documents I in fact even tendered with the plaint. Oral evidence of the father in course of cross-examination and
ground for producing this that you have not stated.
Paragraph 25. In course of cross-examination in the partition suit, father was asked as to who are the owners of flat 3A and 3B. Father could not properly reply to such simple questions. Plaintiff further states that it will appear from the cross-examination of the father. Father was in poor mental health and could not even understand or comprehend simple questions put to him and gave irrelevant answers to simple questions during cross-examination. Plaintiff further states the father at the time of cross-examination was in poor physical health.
Fact of that auction notice stated in these pleadings.
But those are not there.
Then
Those will, auction notice and those documents will show, A, that the
most
brother.
of the documents are not relevant.
Paragraph 32, your lordship will kindly
You have
see.
chosen to give, so I can only give you a liberty to file a fresh application.
Kindly see paragraph 32. I stand to my junior correctly points out, that those ingredients are also there. That this property was attached pursuant to proceedings before learned debts recovery tribunal. Plaintiff states that the flat number 3B was under attachment and proceedings had been initiated for sale of the same by recovery officer. Father was stopped from transferring or gifting his undivided share in flat number 3B in favor of defendant number 1 or any other person. Plaintiff further states in well-settled law, any transfer which is under attachment is illegal. So, these documents to show that there was in fact an attachment order in subsistence when the deed of gift was allegedly executed, is definitely relevant material. And I had also I will come with judgments of our court. A saying that at such a nascent stage where there is no prejudice that is going to be put to the defendant. We are at the stage where my evidence is to begin. It is not as if I have concluded or defendant has given its evidence, they will be put to great hardship. At such a stage, the lenient view should be taken. If necessary, I can be put to terms as to cost. And secondly, the relevance of documents, but to some extent, definitely, but not a roving inquiry as to what these documents are.
This has to be not a roving inquiry.
Yes.
You have to show satisfied.
But your lordship, I'll show your lordship the impugned order. Learned judge has completely glossed over documents A to EF, which relate to the mental faculty of the father, who is the executant of the deed of gift. Today he is no more, he has died. So, what is the best evidence to show what was his capacity at the time of execution of the deed of gift is surrounding circumstances of that relevant point of time. But that, in my respectful submission, is certainly relevant for the purpose of adjudication of this suit. And there are also medical documents in the schedule. Number F, if your lordship sees, medical document of Murari. There were also instances, I know because I have been appearing in this matter for many years. Even before the Honorable High Court at Calcutta, he had come to affirm an affidavit. He was refused by the Oath Commissioner. Even that I understand has been disclosed. Yes, number I, document of refusal of Calcutta High Court's Oath Commissioner to allow Murari Mohan Kejriwal's affidavit. And now your lordship kindly sees the order impugned. Learned judge has only said that what is the need for auction notice and so on and so forth. Nothing to do with these documents, which will definitely be a pointer as to what was his frame of mind, whether he had sound disposable faculty in the year 2016.
Is it the law that if you have not annexed those documents along with the plaintiff, you cannot rely upon that at the time of evidence?
But I require the leave of the court. I require the which is
also you have sought for leave.
That is why my application.
So the documents, you can seek leave of the court at that stage also.
Well, that application has been rejected. Today, your lordship appreciates.
Order 7, Rule 14.
Yes.
That does not say that if that is rejected, you are precluded from adducing evidence by tendering those documents. They are also subject to the leave. You can satisfy all documents.
Your lordship
when you are tendering each and every document, court can consider that.
I understand, but your lordship understands how it becomes in the lower court. Well, the moment I go to do that, objection will be raised.
Has to be.
Well, this will become.
Yes, objection. Then the court will apply its mind on each and every document. I think that is the law.
I was carrying a few decisions. If your lordship considers that because the impugned order, if your lordship kindly takes page 101.
It is your own suit.
Yes, it is my suit.
So you want to delay this suit?
No,
absolutely
not. I am ready.
You have an opportunity to adduce this.
If your lordship in that case clarifies, gives that one line that the learned judge will take each document, consider each of them at the time when the same are tendered in evidence.
The learned advocate appearing for the petition Mean September. September, yes. Yes, next, end of the month of September. Yes, next. Yes, Mr. Banerjee.
Very short point involved. It is appears to be no longer res integra, but I'll have to argue into the judgment a bit. Lordship knows that there's a provision for pre-deposit when one files an appeal before the DRAT from an appeal from an SA proceeding dismissed.
50%.
Yes. Now that is on the debt due and payable. It appears to be no longer res integra, that the debt due and payable includes the amount in the 13-2 notice plus interest up to the date of filing of the appeal. There were a few judgments earlier which said only 13-2 notice, but they were looking at it myopically in the larger conspectus. Now it is no longer res integra because there's a judgment to justice Amar Shah. I'm not really on that. I am the borrower. There was a group loan in which I was one of the notices in the 13-2 notice. I challenged
the impugned order.
The impugned order is one by which 50% has been directed to be paid as pre-deposit. There's a condition of waiver also up to 25, but 50% has been directed to be paid, number one, despite my application for waiver in the appeal. And the amount has been quantified to be the amount that will be accruable till the date of filing of the appeal. That will be the debt due and payable for the purpose of that 50%. Now, regarding the second, I really do not have any axe to grind. It is no longer res integra. I have checked up a lot, just Amar Shah judgment saying
so
that
now you are from reduction to 50 to 25.
One is reduction from 50 to 25 in view of the fact that it is an educational institution, a group of educational institutions which the bank has been chasing up in several forums, one to the detriment of the other. There has been a suit filed even by the bank.
What is the other point?
The other point is whether the debt due and payable will take into account the payments that have been made after NPA. That is sub silentio in Amar Shah's judgment.
I think there is also a decision on with that.
This one I checked up. This has come to be slightly late
on that.
It's slightly late.
This point has also been decided.
Now this I'll have to just check up and come back. The bank is already there. The bank is the only opposite party. If your lordship can keep this subject to keeping everything open, any day I can come up and finish it off. There's no need to go into facts. Complete question of law.
And from 50% to 25%.
50 to 25, I have a very good case. I'll tell you. It's a discretion. After all, yes, 227 quotation, unless I can show that absolutely perverse or it's a discretion which is
the discretion has been exercised one way by the appellate tribunal.
Just because another view is possible, 227 will not be exercised. But if the appellate tribunal has not considered various aspects of the matter which were pleaded in order to have the discretion positively exercised, that leaves a small room for your lordship's interference. I will not take my case higher than that.
If that is so, if both of you agree that it is has not been considered, I can direct the appellate tribunal to reconsider that.
Please do that.
If his points has not been considered,
within a given time, let him consider and come back. Because
according to him, I have not looked at the papers. According to him, he has prayed for waiver of the that pre-deposit from 50% to 25%.
If your lordship kindly has a look at the waiver application once. That
if you want to get into merits,
he says that what the points were taken not considered. That is according to
supplement. These were not being at the first threshold even put before the tribunal.
No, there was a supplement.
Contention is it's an educational institution. There are
there are certain grounds stated.
Yes.
No matter. Your lordship,
supplementary has been filed as part of the record.
Supplementary affidavit
in connection with the 18, which is part of the record.
So according to you, in the supplementary affidavit, the results
materials
have
been
given.
Brought. Materials have
Where
been
is that in this page? In this application?
My lord, this has been not annexed here.
But the Banerjee show it to a learned friend.
We have this supplementary.
So if that is so, if those grounds are not been considered, I can direct the appellate tribunal to reconsider that.
My lord, we can go there, but the fact ultimately, my lord, is it's a point of law. All these points were being looked into, considered, my lord, and the tribunal thereafter arrived at a decision, my lord.
Show me the consideration, that part, how it was considered.
Lord,
where is the reasoning? for not considering the prayer for reduction from 50% to 25%?
Because they didn't provide any reasoning to that effect. Their only contention is there are cross applications pending, matters filed before various forums. The borrower has unnecessarily been drawn into cost mitigating litigations.
So according to you, there was no prayer for waiving?
Absolutely, my lord. That's what I wanted to show from the waiver first.
Waiver
application.
Show me.
Waiver
That has not been annexed.
No, not been annexed. So I am carrying a copy of the waiver, my lord.
Page 4, prayer.
Lordship will kindly come to page 3, para 5 once.
No, Mr. Banerjee, your prayer is from exempting you from making deposits, not for reduction from 50% to 25%. So you wanted complete waiver.
Untenable, but I did not want Milord to make payment.
That is the appellate tribunal says no, in view of this, it's not your from reduction from 50% to 25%.
Order 7, Rule 7, Lordship can read this as containing that prayer. It's not beyond it. They can understand what is following for the Lordship. I bow down.
But you have not also shown me from your submissions there that you have said, no, all right, please reduce it from 50% to 25%.
I'll show you, Milord, what the
Show me that no, supplementary, Mr. Banerjee, may be there. Show me from the order impugned. Yes. That was your submission before the appellate tribunal. That submission was not made. The appellate tribunal was right.
Please come to internal page 2. Key supplementary dara na reba. Internal page 2. Learned senior advocate for the appellants would submit that an amount of 22 crores was deposited by the appellants before classification of the loan account as NPA, and a sum of rupees 8 crore was deposited after the classification towards the outstanding dues of 14 crores 73 lakhs and odd, as claimed in the notice under 13.2. It is further submitted that the total amount of rupees 30 crores and 74 lakhs and odd is deposited by the appellants. Hence, they are not required to make any pre-deposit because there is no debt due. That is the argument. It is further submitted that under Section 18 of the SARFAESI Act, appellants are required to make a pre-deposit of 50% of the debt due. Amount mentioned in the notice under Section 13.2 of the SARFAESI Act shall be treated as debt due. Accordingly, requirement of second proviso.
So, according to you, there is no debt due.
Yes.
That was only your submission. Show me the finding of the tribunal with regard to the debt due.
Now, Milord, kindly comes, Milord, to the next page, page 3. Let me exhaust, Milord, my submissions which I had made. Page 3 is again my submission.
Yes.
Paragraph 6. Learned counsel for the appellant has also drawn my attention towards the supplementary affidavit filed by the appellants, where the deposits made by the appellants were mentioned, which also finds place in the opposition.
So, this is all with regard to the deposits you have made. You have only canvassed that.
Yes. Now, after that, Lord, 8. The intention of the legislature is not to include interest of the amount of debt due.
Yes, that is a submission on merits.
9. Debt means any liability inclusive of interest, para 34, etc. Nilkant. And then this is it. Accordingly, I am of the considered view, make pre-deposit of 50% of 28 crores within a period of 4 weeks. Lord, I'll tell you, Lordship, what appears to have been argued with much force there is the question of whether debt due will consider interest or not.
Not a question of waiver from 50 to 25.
There's a second aspect to it. Whether that debt due will have the interest component or not was argued. It was also argued that there's no debt due. Just by a 13.2 notice quoting something as a debt due cannot become a debt due if I have already made payments before and after. That has to be factored in. There, Justice Imar Shah's judgment is sub silentio. That point has not come up for consideration. Justice Imar Shah falls back on a Bombay High Court decision in which one of their lordships was a party.
Bombay High Court's view was...
And Bombay High Court's view was quoted with approval. Approved and said that same language used, that therefore up to the date of filing of the appeal, which is completely all right. There's no difficulty there. What happens in the event on the face of the record, because these are materials which were put on record before the tribunal, to which an opposition was used by the bank. So the bank has dealt with all this. Now, what happens if on the face of the record one sees that there is no debt? Then, is that 13.2 be all and end all? Can one not crash through it and to find out at the date of filing of the appeal what is the debt due and interest recoverable thereon? This point is sub silentio. I checked Imar Shah. What was argued before Imar Shah was 13.2
that figure is the debt due when the action under SARFAESI starts. After NPA, you cannot keep on adding interest. Therefore, for the purpose of the appeal, for the purpose of considering the amount of pre-deposit, 50% of which will be directed, you can't add portional interest to that amount in 13.2 because then you are adding interest in an NPA, which you can't. Justice Shah said nothing doing. In Bombay, we have dealt with it. That 13.2 figure cannot be a static figure. If you have not paid any amount and if it accrues interest, for the purpose of valuation of that amount, certainly that interest component will have to be taken into account. On that same logic, and because a judgment is only a ratio of what it actually decides and not what logically follows therefrom, on the same logic, I don't have a judgment today, I'm looking for it. If there is material on record to show that amounts were paid on either side of 13.2, not factored in 13.2.
Can that be gone into at this stage? That has to be decided on merits.
This is the question.
So you are trying to question the NPA.
I have.
So that cannot be decided at this stage. That is on the merits.
Only thing is,
Mr. Banerjee, that is on the merits.
Then that those 13.2 judgments are also at that.
Those are on the merits. So you can succeed. If you succeed, you will succeed in the appeal. Yes. So that cannot be considered. So now you are trying to question that NPA, the amount of that NPA.
I bow down. The question is, for the purpose of that valuation, what is the touchstone? 13.2 is the touchstone. If the judgments were estimated at 13.2 is the touchstone, I am out. But judgments are not laying that down. Judgments are saying post 13.2 incidents are to be looked into for the purpose of calculating that amount. Interest in case of non-payment, set off in case of payment. If interest in case of non-payment is one of the indicia which will add up to the 13.2 amount for the purpose of arriving at amount X.
Show me that this point was raised by you before the appellate tribunal.
Definitely.
And how it has been dealt with?
Tribunal hasn't dealt with it at all. Please see, it's a shortish judgment. It's not dealt with at all. Please come, my lord, to it was carried away by Justice M.R. Shah's judgment. Please come there to 6, paragraph 6.
These deposits were made pre 13.2 or post 13.2?
Post 13.2 also. Some pre and some post. Here are the deposits. Here is the accounts. That was on record. Bank used an affidavit of opposition to it, did not dispute it. Now the question is, therefore 13.2 is not your iron curtain which cannot be penetrated. If it can be penetrated for the bank in accruing interest, why can it not be penetrated for the borrower for reduction of amount? Potentially I can be undone. If I can't pay 50%, then I'm out. Potentially I can be undone.
No, Mr. Banerjee, your submission was that kindly come to paragraph 8. This was your submission on this. The learned senior advocate for the appellant submits that the intention of the legislature. Yes, so that was the only submission made before the appellate tribunal on that.
With great respect, the supplementary affidavit doesn't say
Mr. Banerjee, I'm not disputing that you have annexed some materials in the supplementary affidavit, but not raised at the time of hearing before the appellate tribunal.
Permit me to raise it first time before your lordship under 227. No. Point of law, complete point of
law.
So
if you have not raised, Mr. Banerjee, if you have not raised,
you have been given
that you have not pressed that point.
So for that, kindly permit me to return on that very precarious point. If I can satisfy, well and good, otherwise I go. It's a very simple thing. Nothing beyond it. If I succeed, I succeed. I fail, I fail. Point is that.
What do you say to that?
My lord, I'm carrying the M.R. Shah judgment once.
No, according to him, that
I would just like to address that point.
Point 227, whether I can raise it for the first time in revisional jurisdiction when I have not raised it before the first original forum. If it is a point of law, whether it can be deemed that I have given up that point by not arguing it. That's the short point.
My lord, that point in itself has been dealt with in M.R. Shah, which my learned friend is saying is sub-silent, so has actually been dealt with in M.R. Shah.
No.
This, your lordship, is against the final judgment which has been passed in the essay. So all these points which my learned senior friend is arguing here has been dealt with, considered and decided. Thereafter, the essay has been dismissed. Now his contention is that I have made payments after the 13.2 was issued. Those payments are to be calculated apropos the amount which.
Where is the order of the tribunal?
Well, the order of the tribunal is annexed at the last page.
Not the appellate tribunal.
The essay I am carrying. Essay has not been annexed.
Not that.
There they said you could not prove, etc. 13.2. These payments have not been taken into consideration. And that is the error in the order.
এই অর্ডারটা লাগিয়েছো? বাহ, ভালো করেছো। And one more thing, Your Lordship, which is very important. Here, the bank has not taken any steps either to take physical possession of the property or take any steps for auctioning of the property.
No, symbolically,
the borrower, as on date, holds on to the property, is enjoying the property, appropriating monies therefrom, but not willing to come and make payments.
You filed a
So where was this point raised in the essay that he has made these payments?
Well, that point though was not raised by them.
No.
That point was also not raised in essay.
No, my lord. Your Lordship sees.
Subject to Your Lordship's correction.
They're saying it's the first contention was that the 13.2 notice is only being issued to the mortgagers and not to the borrowers. The rate of interest is exorbitant.
RES which have been filed, my lord. Most of these payments, including some of them, are made even after, my lord, the essay has been filed. I will bring that material on record and satisfy Your Lordship. It is nobody's case, I hope, that these payments are being disputed. The effect of them may be disputed.
No, it's not about whether the payments have been made or not. That can't be
17.
disputed.
Attack was against section 13.4 in terms of symbolical possession.
Your Lordship kindly looks from para 9 onwards.
Payment scenario over there, it's not the bank's case that these payments have not been made. It's not even the bank's case that these payments have properly been considered by the first forum and said, no, these are not payments in the eye of law. That's not the bank's case. And for the purpose of waiver, my lord, I don't think it can stretch that far.
No, waiver that was not urged, Mr. Banerjee,
Yes, yes.
in that way.
Yes.
It's a complete waiver. You have said I am not required to deposit anything, not from 50% to 25%.
Under Order 7, Rule 7 can read it down to mean incomplete waiver also. That is within the scope.
No, that was not argued, Mr. Banerjee.
I'm
For
arguing.
waiver, you have to make some points. For waiving from 50% to
25%
25%.
is a question of mixed question of law and
Yes.
fact. This is
So if
complete.
you have not made that prayer, the learned tribunal has
Could
not
not have
gone
made-
into
could
that
not have
because your simpliciter argument was that there is no debt due for me to.
Therefore, no question. So, my lord, for that, I'm humbly seeking Your Lordship's leave to raise it here. I say it's a pure question of law. That part does not require any fact to be gone into. Question is whether the 13.2 is impermeable or whether it is impervious or it can.
What was the demand for? What was the amount?
There were 3 loans which were clubbed together and my lord's demands made.
Yes, what is the total amount?
Totalটা কত ছিল দেখতো দিদি? 13.2 was 14.73 crore.
How much amount you have been directed to deposit?
50%, my lord, of 28.
This is nothing, Mr. Banerjee.
My lord, let's
Deposit, get it succeeded.
50% of 28 crores. When I say, my lord, that I have made payments over 34 crores, I will be undone. The bank eats it, then gets it by way of affidavit. It's like eating the cake, having
That's
it
what
too.
the law is.
That's not
All
the
right,
law.
when do you want?
Whenever.
When
Lord, next week, whenever Your Lordship keeps it.
After some argument, Mr. Banerjee, learned senior advocate, appealing for the petition.
এছাড়া তো আর তোকে সব করেনি। May I file the affidavit of service just?
Affidavit
was a
service
KPI?
file in court today is taken on record. ওপরে লিখে দেবেন। The opposite party একটা লিখে দেবেন। The opposite party are represented by its learned advocates.
এটা কি হবে?
Yes, call the next matter.
31.
Oh, order.
Before,
The learned advocates. What learned advocates?
By the order impugned, Lordship, my application under Order 26 Rule 9 has been kept in abeyance till the completion of the evidence. The learned trial judge has held that my application is premature. Lordship, my evidence of PW1 has been completed. This is a suit for declaration of title and recovery of possession I am claiming that the defendants have encroached
It's
my
a
land.
case of encroachment.
Yes. I filed an application under Order 26 Rule 9 on this stage when my PW1 was just complete. Now, Lordship.
So what is the difficulty, Chakravarti? It has not been dismissed. It has been kept. The learned trial judge is of the view after evidence it could be
Because
taken
Lordship
up.
kindly appreciates the report of the commissioner will also go as evidence.
Yes.
So, Lordship, that will be on record. Based on that, Lordship, I can adduce further evidence.
How many more witnesses you will examine?
Only PW1 has been completed. In my application, I have stated
How many more witnesses you have to depose?
that, Lordship, I have to take instruction. But I have stated that I want to adduce further evidence. At page 38, I have stated that in my application under Order 26 Rule 9. My application, Lordship, starts at page 37 and the points, Lordship, are mentioned at page 40.
Order 26 Rule 9.
Lordship.
When you file this application,
Lordship.
after the evidence started of PW1,
Yes, yes. Page 38, Lordship, paragraph 6.
the evidence of PW1 stands completed.
Yeah, no, PW1 stands completed and the plaintiff wishes to adduce further evidence.
Further evidence of whom?
Of the other witnesses.
But it has been fixed for further evidence of PW1.
That is wrong, Lordship. Should be true.
Are you sure that PW1 has been concluded?
Yes, Lordship. That is my specific instruction, Lordship.
Mr. Chakraborty, learned advocate appearing for the petitioner submits that Yes, Mr. Kundu.
My lord, I appear for the opposite party.
You have been served with a copy.
No, my lord, we've not been. We've just appeared seeing the list, lordship. We've not been served with a.
Have you lodged any caveat?
No, lord.
No.
Yes, Mr. Kundu, what is this matter about?
I'll come to the last page, my order impugned.
Yes.
My lord, the today is fixed for hearing in respect of the petition under section 7(2) of the Westmoreland Premises Tenancy Act 1997, filed by the defendant. Both the parties filed. May I kindly come to the at the outset, I am skipping these two paragraphs. At the outset, it should be mentioned that the defendant has not adduced any evidence for establishing the amount of rent claimed by him. Apart from that, it appears from the record that the defendant filed an application under section 7(1) of the Westmoreland Premises Act 1997, which is allowed by the court on 8/2/2022, directing the defendant to pay the admitted arrears for rent since January 2013 and to pay the current rent from the month of January 2022. The court deposit challenge filed by the defendant reflects that in compliance with the order dated 8/2/22, the defendant deposits the admitted arrears of rent since January 2013 to December 2021, along with the statutory interest amounted to be such and such within 1 month from the date of passing of the order. But the default was for 108 months and the defendant admitted the same. Though the defendant stated in the petition under 7(1) of the Act that he is a defaulter since January 2013 till December 2021 for 108 months, but deposits the arrears of rent for 96 months only. But this was a wrong calculation on the part of the learned advocate appearing for the petitioner before the lordship. Therefore, it was deposited for 96 instead of 108 months. And the petition under section.
Mr. Kundu, admitted amount of arrears.
That's true. My lord, this is bona fide mission on the part of the learned advocate.
Cannot be helped. Cannot be helped.
My lord, can you impose some cost? But tomorrow is fixed for a peremptory hearing. Can you give me some protection?
What protection, Mr.
Well, I'll deposit.
Cannot be done.
Impose some cost on.
My lord, my instruction is that they are habitual defaulters, and may I hand over a copy of the next order, that is 20th January 2025, your lordship.
Tomorrow is fixed for peremptory hearing.
Where is your application under section 7(2)?
Yes. At page 41.
So the default was for 108 months.
Lordship.
But you have paid for 96 months.
96 months. Impose some cost.
Nothing can be done.
Paid also for 9 years. But it's a genuine mistake.
What he knows for what? He has paid only for 96. It's not his case that because he has admitted those. He's not his case that he has paid 108 months rent to the learned advocate and he has deposited 96. It's very easy, Mr. Kundu, to put the blame on the learned advocate. This application under Article 227 of the Constitution of India is at the instance of the
33.
So I appear on behalf of the KVA. Before my lord, this is a open and shut case. Only one window. I'm being very candid. That same thing, my lord, my lord's judgment in Parvati versus Pavan Agarwal is staring at my face. But my lord, this is default. But my lord, there is one particular window of salvation in view of the judgment of 2024 October of Honorable Supreme Court. If I can satisfy my lord on that particular point, I'm just saying what I will not waste much of my lord. Here, my lord, 7-1 application made within time. Arrears of rent deposited. No issues about that. 7-2 adjudicated, saying no default. Everything over. Now 7-1C, 15 days. Since the rent was payable according to Bengali calendar month, there is a problem with Hindi and Bengali calendar month with the new generation clerks and even to some extent advocates also. Be that as it may be. Now, we went to deposit it on a particular day being 16th or 17th of December. And that
15th of December.
15th of December was the cutoff date. It was a holiday. Clerk went on 16th or 17th of December 2024 to deposit it, but now the department refused to accept it, saying that Bengali calendar month, that subsequent month, they make a note over there. So you have missed the bus, and therefore we will not accept it. Now the clerks, as they try 1 or 2 days, and then after that, at the first on the war footing, we made an application. Though 151 will not lie, my lord's judgment is there, but my lord, I'm coming. Just my lord, give me 30 seconds. So
where is the Supreme Court judgment of 2024?
My lord, what it is saying, my lord, why? It is saying that where Limitation Act under Section 40 of West Bengal Premises Tenancy Act, when it refers to Limitation Act, will apply to those provisions in the Act where no specific time limit has been prescribed, which is lesser than the Limitation Act. Now, as far as 7-1 is concerned, in no unequivocal terms, it has been said 1 month. 7-2, 2 weeks, not beyond that.
2 weeks.
2 months. I stand corrected.
1 month thereafter, one extension.
So yeah, but as far as 7-1C is concerned, it said 15 days. By the 15th day or 15th day of every succeeding month.
Yes.
But my lord, if anybody makes an app, if my lord kindly comes to 7-2, remember 7-2, it says that if an application is made for extension, it can be done. 7-1 says extension cannot be done. Now, my lord, 7-1C, my lord, there is, my lord, a window, my lord. If my lord kindly deliberates that, then my lord, I can come tomorrow, my lord. Otherwise, this is on that. So, my lord, I was just going through that judgment. My lord, it is there, my lord. I can give the citation.
Reference. Relying upon Devash's first paragraph 17.
16 million. I suppose, my lord will
where it says that the proviso is appearing after 7-2 shall apply to 7-1 also.
My lord, 16 is the only salvation, my lord. Paragraph 16.
16 or 17, 16. Where it says that though the proviso appears after section 7-2, it shall also apply to 7-1.
My lord, if my lord reads it with me, maybe after tomorrow, my lord, maybe.
Mr. Trivedi, next paragraph has shut you out of that.
If my lord reads it with me, maybe a day, because my lord, this is all these cases are a series of cases. My lord, we are just trying to make a dent if we can, because my lord will kindly say it is too hard.
But you are trying to rely upon the reference.
My lord, that
Supreme Court reference is not on this point, Mr.
My lord, that is not on this point. That is not on this point. That is not on this point, my lord. But because my lord, I don't
trying to submit on 2024 judgment reference is not on.
No, my lord, I as my lord's officer, because at the very beginning, my lord, before opening my brief, I told my lord the only window of salvation is this, because unnecessary arguing on other points where my lord's judgment passed in, I suppose, in May 2024, which I
two judgments, I think one in March or April, another in May.
May says 7-1, 15 days is also mandatory, what has fallen from my lord. So I cannot, being my lord's officer, I cannot argue beyond that. But my lord, I can always argue on a point where, my lord, if my lord reads with me that particular judgment, can I come back, my lord, tomorrow with that judgment, so that if my lord, at least 30 seconds, my lord. If we can, it is our duty
Whether
to
it's
try.
not 30 seconds, you can make your submissions, no difficulty on
we have
that.
to try, Millard, because otherwise, Millard, all the windows, as far as these are concerned, and now 7-1 also, Millard. Now, this has become a Herculean task because, Millard, we have to saddle this responsibility with the clerks. In all Mufassal courts and everywhere, Millard will kindly take a pragmatic view that it has to be given to
You
the
have
clerks.
seen the judgment of Parvati
I
Chaudhary.
know,
There, what happened, there was no default in the real sense. Only, I think, 10 or 15 rupees less amount was deposited.
Less amount was deposited.
There was no actual default.
No default. There was actually that number, the magic numbers, 92 and 39. It was like that.
That is the only miscalculation for those
The
periods.
numericals.
And that application was filed prior to the plaintiff bringing to the notice of that fact.
is-
Defendant on
that
his
is-
own said, look, by mistake I have done this. Please allow me to deposit.
But Millard, I believe after fighting for so many years, the judgment of my Lord Justice Sudhanshu Dhulia has brought some Millard salvation to the litigants who are for tenant with regard to that retrospective. But Millard, therefore, we are trying to make a point, Millard, even at the cost of Millard. I will come with that interpretation of that judgment. Otherwise, this is because this is 7-1. Now, Millard, what is happening, Millard? The clerks who are going to deposit, Millard, keeping a vigilance on them is an Herculean task for the learned advocates. And this happens as a matter of routine, month by month. Now, when it is being deposited within 15 months, after 15 days, Millard, it becomes a Herculean task. And Millard, therefore, Millard, I am trying my level best against all odds. Just, I will
Mr.
take
Trivedi,
my Lord, 1 minute
Mr. Trivedi, learned senior advocate, appearing for the
1 minute of my Lord's time tomorrow. Millard, just will get Millard, maybe Millard I can.
Because I also want, if you can give me something.
Otherwise, yesterday evening, Millard, I got this brief. I refused it, but then the person was crying, and the clerk came and he said that it was his fault. So, Millard, therefore, Millard, I knew it's an open and shut case, though I'm not wasting much of my time.
Yes, next.
Complete.
24. Millard, I am appearing in person.
Yes.
Millard, I am a successful preemptor in exercising a right of preemption under Section 8 of the West Bengal Land Reforms Act. I obtained an order of preemption in the trial court below, and that order was affirmed in the appellate. So, wherein I put a petition under Section 9(5) of the West Bengal Land Reforms Act for a correction of LRR, Learned Executing Court as well as the appellate court rejected the same on the point. Until and unless the modification is made by the appellate court, the Munsif shall have no jurisdiction to send the copy of the same.
Where is the order of the executing court?
Order of the executing court, my lord. The relevant page is 69. Sir, I read out, my lord.
There were how many appellants? 5 appellants.
There are, my lord,
5 appellants.
6 appellants, my lord.
6 appellants. Yes. So how can it be corrected only in your name?
Sir, my lord, this is a factual circumstance of the case is that my deceased father, whose name is Sonatan Dotto, he
you are
during his
claiming by
lifetime-
virtue of a will.
will.
All right.
Yes, my lord.
So, but for that, this order cannot be modified. You have your recourses available under the provisions of
I
the
am
Land Reforms Act.
I am the claimant of the decree, my lord.
Maybe.
146, my lord, kindly refer. 146 of CPC, my lord. I am the claimant of the decree.
Yes.
Proceedings by or against representatives.
Yes.
Save and except otherwise provided by this court or by any other law for the time being in force, where any proceedings may be taken or application made by or against any person, then the proceedings may be taken or the application may.
Yes. So how does it apply to your case?
My lord.
How does it apply to your case?
My lord, this is my disease.
If during the pendency of a proceeding someone dies, now to prefer an appeal, it can be by the legal representatives.
No, my case is not that. My case is not that. During the pendency of the preemption proceedings, the entire
your grievance is that you want correction of the record of rights. Make an application to the block land and land.
No. There is a provision under section 9(5) of the West Bengal Land Reforms Act. If my deceased father would have been made recourse the provision of the same application, land administration should have been allowed. Because only the courts of rejection of my petition is that until and as modification is being held by the appellate court, then modification shall have no jurisdiction to send the copy. This was the only score of rejection.
It was granted.
Probate was granted in the year 2004.
And when the appeal was dismissed by the appellate court against preemption.
No. In the trial court as well as appellate court, I own.
I'm asking you, what is the date of the judgment passed by the appellate court in the miscellaneous appeal? Give me 2 dates. When the appeal was disposed of by the appellate court and when you obtained the will.
30th May of 2021.
30 or 1?
2021.
30 or 13?
31st one. 31st.
31st of
May.
May 2021.
2021.
The appeal was dismissed.
Appeal was affirmed. Means the trial appeal was dismissed, my lord. The trial court judgment was affirmed.
And when the probate was granted?
Probate was granted in the year 2004.
2004? What is the date of the granting of the probate? Why you did not bring this fact to the notice of the appellate court when the appeal was pending?
Only to avoid criticism of abatement, so I make ourselves.
Where is the question of abatement? There is no question of abatement.
Sonatan Datta died in the year 2021. 22. So, sir, I have to save the legal proceedings. Pending before the.
When the probate was granted?
Probate was granted in the 2004.
2004? When that Sonatan Datta died?
Sonatan Datta died in the year 2022. 2002, my lord. 2002.
And probate granted in 2004.
2004.
So why did not bring to the notice of the appellate court with regard to this?
At the time of execution, I bring.
I'm asking you, why did not bring this fact to the notice
Because
of
there was another proceedings violation miss case was, one thing,
petitioner is directed to serve a copy of this. Next.
Petitioner Lordship. Oh,
The
the matrix for expeditious hearing.
Yes, Mr. Ghosh.
My lord, I mentioned the matter, my lord, the two matters, my lord, your lordship can see, I am for the petitioner, my lord. I filed a suit for preemption under the Mormon law. My lord, if your lordship kindly comes to the plane, page 32, my lord.
You have filed before the senior division.
Senior division. Now, my lord,
what is the valuation? So valuation is, as per the valuation, suit lies before the senior division.
No, 3,80,000 in view of section 21, the court says that it will lie before the appeal court has no.
No. Suit was rightly filed before the senior division.
Senior division.
Suit was rightly filed before the senior division.
My lord, I have filed an application for injunction restricting the preemptive from changing the nature and character. That was rejected. Against that, I filed an appeal before the district judge.
District judge, it's not maintainable.
That is the reason, my lord, we have proceeded with that. That is the reason, my lord.
So you have to apply before the division bench.
Yes, that's the reason, my lord. What I was humbly praying, my lord, let me withdraw. My lord, when I was given.
What you will withdraw? Now the appeal.
The revisional application, I want
not maintainable.
Yes, kindly see the imprint order.
Yes. So, Mr. Thereafter you filed the civil revision.
Yes, that is the reason, my lord. Your lordship knows order 23 to rule 3. One liberty, my lord, to apply before the appropriate forum. This will not prevent. And one thing, my lord, kindly allow me to get the certificate copy of this order. The forum is fixed.
No, forum, otherwise revision may also
My
be
lord, I
maintainable.
have a very better case, my lord. I would not open my brief. But this case, my lord, but your lordship, this is a suit, my lord, degree will follow under order 20, rule 14, then regular appeal.
Thank you, Mr. Ghosh.
I'm getting.
Grateful.
But I know today this is not the time for mentioning. But my kindly
Then why are you mentioning?
under compelling circumstances, kindly see this order and the file because I lodged a caveat. My junior, kindly see once the file, my lord. Your lordship knows, my lord, in the back side, my lord, there is a reporting, my lord, regarding lodging of caveat.
Yes.
My lord, unfortunately, now, my lord, I have been told by the counterpart that I missed the matter. Maybe I missed, but my lord,
Yes. No copy was also served upon you.
nothing. My junior name is there, my lord.
Better Calcutta to be mentioned at the other one. Please inform the other side. Calcutta to be mentioned at the other one. Mr. Mukherjee, this should have been pointed out. It's very difficult to look into all the papers where there is a caveat.
Problem is that I was also in dark. Now they have communicated the order today, and today I came to learn.
It have been mentioned that there is a caveat. If it is,
they should have ought to have, my lord. And my lord, I have the, my lord, acknowledgement card that their client has received.
there's a noting also.
Also, and not only that, my lord, when they, my lord, moved the matter, before that also, my lord, I lodged a second time caveat.
কালকে যেতে দিয়ে দিন to be mentioned.
My lord, I would have not troubled your lordship on any other day, any other circumstances. The my lord, it arose. My lord, today, while my lord, the matter was taken up by Lordship Amrita Sinha, my lord, our lordship's opinion was that, my lord, this matter is to be, my lord, heard in the civil division jurisdiction. And my lord released the matter, direct the department to put a number to that.
Yes.
But my lord, I am, my lord, on the threat of eviction. It's a, my lord, I have challenged the propriety of the DRAT's order, my lord, Debt Recovery Tribunal's order. And my lord, while hearing this matter, lordship held it at around 1 p.m. So, my lord, the department has already been directed. If your lordship, my lord, kindly accommodates me.
Who is appearing for? It will appear tomorrow.
Tomorrow, my lord, I will provide the number. And my lord, I will intimate.
The other side.
Yes, my other side was there today representing the bank.
Please inform him.
Yes, yes. I'm grateful, my lord. I'm just provide the CEO number, my lord, to my lord's officer. CEO number to the department. I'm extremely grateful, my lord.
Your lordship, I'm praying leave to file the civil division without the certified copy.
Not now. Yes, call the list.
35.
For the petitioner, lordship led by Mr. Raghunath Chakraborty, the matter is regarding expeditious hearing, and the suit was instituted on 2014, lordship. So after that, it has not been moved yet, and later, on 27th April 2024, the petitioner, the plaintiff, filed the substitution application that has not been.
Substitution.
Yes, lordship.
So unless the substitution is disposed of, suit cannot be directed to be.
And the
where is the application for substitution? When it was filed?
it has not been annexed, lordship, but order number.
Which order refers to the substitution application?
Lordship, order number.
This is a partition suit.
Yes, lordship, partition suit, order number 30. 20.
Order number
30. 29 April 2024. It has been referred to a prolonged date, lordship.
Has been
1
fixed
year.
on 6th of December
Yes,
2025.
lordship, that is the thing, lordship. Kindly
Cannot be preponed.
lordship, because it's a
Preponing cannot be done from here. Then you have to, I can give you leave to apply for preponing, or I can direct to take up that application on that date and to dispose of. Choice is yours. If you want preponing, I will give you liberty to file an application there.
Yes, lordship.
You want that?
Yes, lordship.
And for the petitioner, my lord, order has been passed against the application filed by the defendant petitioner before your lordship under order 1 rule 10(2) to bring the left out party on record. Suit for partition, petitioner is defended before the learned trial court. My application is at page number, my lord, 69. Page 69. Running page 69, my lord. Additional parties application. Paragraph 2, my lord. Profulla Kumar Dotto, who inherited undivided 115 share from Shambhunath. Suit property was purchased by 3 brothers. Shambhunath died at bachelor intestate.
Where is the plaint?
The plaint, my lord, annexed A, my lord. Page number 27, my lord. By the learned trial court without deciding the fate of that application, fixed the suit for witness action. And I have been delivered to rewrite those documents in future in evidence. That's why before your lordship, my lord. For the petitioner. Petitioner approached the, my lord, left out party, but they have denied to supply copy of any death certificate.
You are the defendant.
We are defendant, my lord. We are defendant in a partition suit. We have filed additional party application to bring the left out party on record. Share ratio pattern will not be changed of any parties. But they have undivided.
Where is your written statement?
Kindly see my additional written statement, my lord. Page number, my lord. Page number 61. Paragraph 2, my lord. Paragraph 2 onwards, my lord. Apart from that, my lord, defendant filed one deed of gift by separate Philisti in course of hearing of that application. That was also not considered by the learned trial court. Yes, your honor. Plaintiff will not be prejudiced, my lord, in case of brought on record of the left out parties.
Whom do you want to add?
My lord, legal heirs of Profulla. My lord,
where have you given their particulars?
My lord,
which paragraph?
My application at page number 69, my lord, schedule has been there. Page 71, my lord, of my application under order 1 rule 10(2).
So Sneholata Dotto, Priyanka Dotto, and
Papu.
These are the 3 persons.
3 persons are legal heirs of Profulla. Profulla inherited from Shambhunath. Suit property purchased in 3 names. Shambhunath and my lord, fathers of the plaintiff, and also my our.
No, you have wanted to add only these 3 persons.
3%. They have jointly undivided 115 share in the suit property. Share ratio pattern will not be changed. Nobody will be prejudiced in case of brought on record of those persons. Partition suit, my lord.
Wherever stated this fact of this Neolata, Priyanka and Pappu that they have in your written statement, show me that. In the written statement.
Additional written statement at page number 61, paragraph 2 onwards.
No, show me that wherever stated about these 3 persons have shares. Where is that paragraph?
In our additional written statement, we have stated non-joiner of necessary parties.
Yes.
But in my but Praful has undivided
that you have not stated in your written statement also.
But I have stated in my application also.
That is neither here nor there. So since you have not taken this plea of in the written statement,
Non-joiner of necessary parties. Non-joiner of necessary parties.
Yes, wherever specified, who are the necessary parties who have not been joined, show me that. I want to see that.
My lord.
These persons you have not named. So only vaguely you will say that non-joined necessary parties that will not do.
I have stated legal heirs.
That is neither here nor there. Legal heirs, who are the legal heirs? You have not made those statements there. The suit will be dismissed. How are you aggrieved?
Then, my lord,
the suit will be dismissed.
Then, my lord, anytime decree may be reopened by the non-joining parties, my lord.
They will reopen.
We are
You are not aggrieved. You have not applied for partition. You can also say that this is your share. You can also pray for declaration of your share in the suit for partition. What prevents you from doing that?
That prayer is not available in the plaint, my lord.
Not plaint. In the written statement, in the suit for partition, you are also the plaintiff,
my lord.
So you can pray for your declaration of share. What prevents you from doing that?
Regarding extent of share, I have no problem, my lord. No difficulty.
Yes.
But they have unlimited share.
Yes.
Left-out parties have unlimited share.
Show me in your written statement you have stated that these persons have shares. Please come ready. On the prayer of
37, Lordship, defendant petitioner before expeditious disposal of the suit. The suit was filed by the.
What is the stage of the suit?
Cross-examination of PW2, Lordship. After 3 or 4 months' time was given and the dates are fixed thereafter, Lordship, by the trial court. So the property is lying in a very dilapidated condition. Already a board has been affixed by the KMC regarding dangerous building. I've annexed the photocopy also. And the relevant.
That was at your instance, this notice from the Kolkata Municipal Corporation.
And regarding.
You are the defendant.
Defendant, I have filed a written statement with counterclaim. The plaintiff.
What is your counterclaim?
That 2G attracts. It has been admitted that the original recorded tenant has expired in 2000.
What is the suit for?
Regarding declaration that they are.
Tenancy.
Yes, Lordship.
Declaration of tenancy, and you have set up a counterclaim for eviction. 2G.
And it has been admitted in the annexed cross-examination of PW. Thirty-eight.
None appears for the petitioner at the time of.
Thirty-nine.
Yes.
I'm for the petitioner, my lord. The husband is the petitioner before my lord. The husband filed a suit for restitution of conjugal rights, my lord. Wife filed an application for counterclaim for divorce, my lord. A Section 24 application was filed by the wife claiming maintenance.
For the husband or the wife?
Husband, for the husband.
5,000 has been
My
granted.
lord, I would consider one thing during the 125 application, before the trial court, criminal court, and the appeal court, there was a revision filed. The wife had deposed that she has her own income and she is doing a job.
What is the order passed under section 125?
My lord, the order passed under 125 that maintenance should be given to the wife and that was a revision was filed before the additional district judge. The order is at page 23, my lord.
What is the amount directed to be paid?
Only the son, minor son would get the maintenance. Since the wife, if my lord turns annexure C, page 21, the deposition, examination of chief of the wife.
What are you doing?
The husband is the laddu seller. Laddu seller makes laddu in house and sells it in the mandils. Like Bhutnath and
Engineers. Fabulous income.
My door to door and
5,000. After all, you have also a son.
Towards the
You have
son,
also a son.
Towards the son, I have no advance. I am paying to the son.
Think it that you are paying for the son, 5,000.
She is now living with another person, my lord.
That is no institution of conjugal rights.
Right.
Even after knowing that, you want to take her back. So don't now take.
But if my lord takes up annexure C1, page 21, where she has admitted that she has her own income, my lord. Page 21, my lord, deposition before the 125 proceedings, my lord. Examination of Chief PW1. I have a male child on November 20th. Thereafter.
Where?
My lord,
yes, my husband.
I have joined a service, my lord. I have at the time of I have joined a job in November 22, from where I am getting a rupees 5,000 per month. It is the deposition of the wife. See,
no, this deposition was. What is the date of this deposition?
My lord, this November 2022, my lord. Against that, and revision application was preferred. Page 23, my lord. The application of 125 was filed in the year 2020.
No, where is the statement in this section 24? Where is the application under section 24?
My lord, section 24, my lord, application is at page. Starts at page 40. Starts at page. Pagination colony. Annexure F, my lord. 40, page 40. Page 40.
Oh, it's a written objection.
Good.
Page 36.
My lord, sorry, my lord, page 36. Affidavit of assets has also been filed by the husband, by the petitioner and the opposite party, my lord.
What is the finding of the learned trial judge on that income?
My lord, the finding of the trial judge, my lord. The allegations and the impugn order, my lord, the allegations and the counter-allegation of the parties against each other subject to proof at the time of trial. It is admitted position that the parties are married and their marriage is still subsisting.
Yes. She admitted that she was having a source of income, but she has left the job to take care of your son.
But we have instructions that she is doing the job.
Prove that. You could not prove that.
My lord, even the affidavit of assets, which was filed, I have annexed the affidavit of assets of the wife and the husband also. My lord, she has never denied that she is doing any job. She has claimed that she is getting maintenance from the husband, which was in the additional district judge has in a revisional application.
What is the stage of the matrimonial suit?
Stage of the matrimonial suit? It's for adducing evidence, my lord.
So I can expedite the matrimonial. Please pay off this. Otherwise, it will be getting delayed. Ashok. Contested application. Yes, next.
May I please?
Yes.
This is my application for, actually, the one application was filed for local inspection, that has been rejected. Why I have filed this application for local inspection? Because this is a suit for eviction on the ground of reasonable requirement and subletting. So in order to establish or ascertain whether I have at all subletting or there is any reasonable requirement, to that effect,
Subletting, how can it be proved by way of
no,
local inspection?
They have alleged that some company on my tenanted portion is running. That is totally false. In order to ascertain that whether any company is running or any trade is running on that room, it's a only room. It is lent out. Let out.
Where is your application for local inspection?
Application page 34. Paragraph 4, 3 and 4. 3, 4, 5. This 3 paragraph. Short application I find.
These points cannot be allowed. You are trying to fish out evidence by way of local inspection.
What has happened? Actually, no, the allegation, if you lost it, kindly have a look to the plaint. It has been amended 2020-22. Suit was filed 2009. It was, plaint has been amended 2022. And
you are the defendant.
It
is the plaintiff's duty to prove.
And so far,
it's not your duty to prove.
That is true, but only thing,
let the plaintiff take the trouble of proving this.
Subletting.
Why are you trying to help the plaintiff in proving his case?
That's true, but plaintiff will not be prejudiced. If any inspection local...
Please don't help the plaintiff. Let him prove. It's his duty.
41.
Lordship, I am for the plaintiff petition.
Yes.
They obtained an order of, it's a suit for declaration and permanent injunction. I've obtained an order of ad interim, ex parte ad interim order of injunction that was stayed without notice in a miscellaneous appeal. Lordship, I carried that order before this Honorable High Court on earlier occasion. It's at page number 30. And there was a direction upon the learned trial court to dispose of the application for stay within 3 weeks.
Since I'm not inclined to take up this application on pass.
I will be petition available.
I am for the opposite party on caveat note.
Yes, Mr. Ghosh.
For evictions, on the ground of default, inter other grounds, the tenant, that is your petitioner before lordships, appear before the learned court below after getting information from the criminal proceedings under section 144. The suit has been filed. That immediately after getting information from the proceedings, I file an information slip before the learned court below. However, I came to learn the suit has been filed. Thereafter, 2 applications were filed, 171 for seeking permission to deposit monthly rent in court, and another is 72 for determination of the areas of rent. But 71 was taken up for hearing earlier before disposal of 72. Because 72 I clearly prayed for determination of the areas of rent as alleged to be due from the plaintiff.
Where is the dispute raised in 7.2? Where is your application under section 7.2?
7.2 I have not annexed it. Well, this has been.
What is the dispute you have raised, Mr. Ghosh?
Well, one earlier plaintiff, a predecessor of the opposite party, he inducted tenant after death of the earlier predecessor to whom the rent is payable by the tenant. That was the dispute. Now the plaintiff has filed this suit claiming to be the landlord. I have said that the plaintiff has first time for the disclosed his status that he became the landlord of the suit holdings. So the area of rent as alleged to be fallen due, the tenant faced difficult as to whom the rent is to be paid. That is the main contention of the section 7.2 applications.
Who inducted you, Mr. Ghosh?
Well,
what is the dispute raised?
Dispute.
Show me from your application.
But I have one copy, just that will be annexed. We have paid certain.
Who, according to you, are the landlords? You have raised the dispute. So plaintiff has claimed X to be the landlord. So if you have to dispute, you have to say who are the landlords.
Well, that is to be determined by the landlord court below.
Mr. Ghosh, if you have not made out any case, what should be determined? Here and now I can say that. There is no dispute in the eye of law.
That is a 7.2 bereft of my particulars that it disputes. 7.2 bereft of my particulars who is the actual landlord, my lord.
7.2 it's your liability. You are raising a dispute. He has filed a suit.
I saw determination of the
Mr.
areas
Ghosh,
of
the
rent.
plaintiff has filed a suit claiming he is the landlord. You are disputing. So once you dispute, it's not sufficient to say, yes, you are not the landlord. You have to say, not you, such and such person is the landlord.
The period of defaults also dispute.
Because it's after all you who have to prove that on your assertion, this dispute will be decided.
Only grievance of
So there is no bona fide dispute, Mr.
only
Ghosh.
grievance of the petitioner before lordships, before disposal of 7.2. 7.1 was taken up for hearing on the ground. It was filed after long period from the date of the receipt of the summons.
All right. I'm setting aside that. Show me 7.2. What dispute you have raised? Show me you have paid the admitted amount of rent.
No, that I have waited the disposal of 7.2. unless the court direct me.
Why? Admission in your application, admitted areas. You have admitted.
Admitted areas and are not deposited due to long advice of the landed contracting advocate.
No. Sue the learned
I
advocate.
have
Sue the learned advocate. What steps have you taken against that? Mr. Ghosh, it's very easy to put the blame on the shoulder of the learned advocate.
But I have
Very
stated,
easy.
I have stated in paragraph 4 onwards of the revision application.
Yes.
Paragraph 4 onwards.
Paragraph 3. This according to you is the admitted due. Have you deposited this? 420.
Kindly come to paragraph 4 onwards of the revision applications.
After
the grievance
back to paragraph 4, for the purpose of coming to paragraph 4, paragraph 3, I am at paragraph 3.
No, I am
Please satisfy me on paragraph 3. On your own
I am
assertion,
confessing my
it's
guilt
an
that-
admitted.
I am confessing my guilt that areas of rent are not deposited.
End of the matter, Mr. Ghosh. This application.
Forty-three.
Thank you, sir. 43, I am for the petition. Ultimately,
That's reached. But think that it will not reach
I am
during the entire day. It is to be taken up at 10:30.
I am grateful. My lord, I have challenged an order dated 25th of April 2025, my lord, wherein my lord DW has
Of April, yes.
so DW of the my lord present petitioner hearing has been closed. Who is the bank, my lord? My lord, petitioner before the lawsuit is a cooperative bank, my lord. What has happened, my lord? A suit filed by the plaintiff as against the bank for reopening of a my lord accounts which has already been closed by the bank and certificate has been issued in that, my lord.
You have
account.
filed a revision application earlier also.
Yes, my lord. My
There
lord,
is no stay.
my lord, no stay, but my lord, matter is still pending. My lord, before your
Lord
lawsuit,
trial
I
judge
have
has rightly observed mere pendency of a
my
civil
lord,
litigation.
that's true, my lord. Even of our best effort, my lord, that could not be, my lord, a hard out. My lord, that is our fault, my lord.
Court cannot be faulted for that.
But my lord, DW has been closed, my lord.
So far, order 6, rule 17 is concerned only minor,
What is the challenge in the other civil revision application?
order 6, rule 17 was rejected by the learned court below, challenging that, we prefer the earlier revision applications, only, correction was that, instead of, cash,
I cannot look into that.
that.
So now you are willing to adduce evidence.
Yes,
So I will record that.
Otherwise, if your lordship
I will
wants
record
to-
your submission.
If your lordship wants to take, tag with this,
There is a civil revision application of which year?
that is 2024.
24.
My lord have jurisdiction, It is also pending your lordship's list also. It is 1647 of monthly list, My client, my junior
1647 of
monthly list.
বার করুন তো 1647 টা wait for some time, if not at 425 ওটা বার করুন।
Very good. Brief আছে, brief.
Let's call the next matter.
Very good. 44.
Yes, Mr. Basu.
First default is could not serve to the other side.
Caveator.
Next is, my lord, point is probably pending adjudication.
Where? Show me the order. Show me the order.
I have obtained one order of, that there was a similar point was urged, but I am not personally sure.
First, look at the order, then place that order.
I know that. That's why I am not placing this order. I've heard that.
What is your fact here?
Fact is, according to me, there is no delay. Even if on the records.
What happened? What happened in this?
Even if on the record it goes.
7-2 rejected.
Yes.
On what ground?
Delay.
Delay means not within 1 month you have not filed the application.
2 days delay. And I could argue, my lord, on the law that it requires a service upon the tenant.
It requires
service upon the tenant. The language itself, my lord, has a. It was served upon a person who subsequently handed over to the tenant. Whether it is authorized or not authorized, that has to be looked into. A letter has been sent in my name.
Where is your application under section 7?
My lord,
7-2. Let me see what is your averment with regard to the service of summons in 7-2.
Go by the records. Don't
Yes, yes.
go by the application.
No, application, your statement. That is because you have to stand or fall on the basis of your own case made out. Please show me what is your case taken with regard to service of summons.
My lord can well appreciate on my hesitating to place it. I will only go by the record.
Then I cannot, Mr. Bose, if you have not taken that point, that is in your application under sections.
Even if I have not taken. Already hearing a piece of the application, record is before my lord. Record will depict, my lord, when it was served.
Please show me section 7-2 application once, then I will go through.
My lord will unable to found anything.
Where is that application? If I can try to find out something in your favor.
That will not do. I know.
No, you have not served upon the caveator, Mr. Basu.
Outside, I say. Yes, well, kindly come to page.
এই পেজও করো কি করেছে কি পেজ করো নি
পেজ
I cannot indicate. But I'll take my.
No, it has not been annexed. No, but
Not paginated.
actually
not paginated.
সার্ভিস হয়নি বলে পেয়ে গেছে কি বলবো
সব গন্ডগোল থাকলে আর কি করবো?
এদের উপরে ভরসা করে কোনো না।
Admission that you have received.
Wrong date. The date, can you see what is the date? Service of summons?
9th of November 2019.
হ্যাঁ আমরা অ্যাপিয়ার করেছি সেদিন
Yes.
I
And you have filed this application on 9th of December. And what is the court's finding?
finding is that there is a wrong application. The date was given, which was given, if I am not wrong, which is prior to filing of the suit. And court is of the opinion, you have 2 days delay, I have no power to convert. I submit, my lord, that there is no delay at all.
কোর্টে বিলিফ রিপোর্টের উপর চলে বিলিফ করেছে 7/11 সার্ভিস করেছে অন দি ম্যানেজার
Where is that finding with regard to a briefটা দিয়ে দিন সিনিয়র অ্যাডভোকেটের হাতে কোনো brief
He told me that there is no service, so I thought I may not be ready. Now the problem, yeah.
No, you are not ready, Mr. Basu.
No, I am ready. But pagination I cannot show. You can see the police report. This is the ground of.
No. Show me the finding in the impugned order with regard.
And this belief report. Report is that on 17th it was served.
Yes. And you said you have received on 9th. Yes.
So if that is there, then my lord, there is no delay.
To his manager, this is a shop room, commercial.
Yes, yes. Very renowned Alia hotel. So Neil is on personal account. My lord has taken biryani for some time also.
So
if you not go by amendments in my petition, this is within time. But if you not look to the record.
So according to you, service upon the manager cannot be said to be service upon the tenant.
Language is there, my lord. 2 days delay, otherwise I will not make this argument at all. And the suit is on the ground of default. There is no default.
So that he will succeed.
Mr. Of the proceeding has to be, had it been a reasonable requirement. But I could not have said anything so much. I should not be so much fussy for us of this. Here is on the ground of default. It's a business house. Service upon the tenant.
80 plus.
বলে লাভ গল্প নেই তোর পিটিশন অ্যাকচুয়ালি আমাদের বৈঠকখানে বসেনি কোর্টে আছে না আপনার ওখানে তো দুদিনে বসে অনেক করি If my lord go to the records of this proceeding, the lords will find and accept my contention vis-a-vis the statute, there is no delay. Famous student, my lord. Us. Probably 80 or 100 years, 100 years.
Almost 100 is completed.
The suit is on the ground of default, but there is no default. But I cannot say anything if my defense is struck out.
No, Mr. Basu, even if your defense is struck out, if that is your case, you can cross-examine the plaintiff. Yes, Mr. Basu, if there is no default they have to prove. So according to you,
another MOP is also.
Say so. Yes. So default, you can say that.
My lord is to some extent correct. If I don't able to dispute that as my written statement, if there is no defense, so I can have to deny.
Even if Mr. Basu, even if there is no defense, they have to prove. It's the plaintiff's liability or the duty to prove.
MOP also
they have to prove. And so if there is a MOP, there has to be an inspection or a commission on that.
On the threshold, I am debarred my defense, I cannot put forward. Can I see the situation? In a case, can you allow me to go back to the facts of this case? What I say, it was my 7-2 statement says it was within time. And the belief report said prior to 2 days, they served upon one of the person who is alleged to be my manager. So if the strict compliance of the statute, my lord, it is within time.
रेडी वारंट की कहाँ है क्लर्क सुकुमार को बुलाओ तो मेरे पास आया नहीं ना आया ना उसका
All right, you serve. Let us see what happens.
Problem is this. It is my fault. I should have been served under the calculation. Petition is also not.
Nowadays, Mr. Basu, it is being moved without telling that there is a caveat. It's very difficult to check all those things. You can say, yes, there is a.
Not that category. So
no, it's not that. Today, in the just after the recess, Mr. Devjit Mukherjee pointed out there was a caveat. It was recorded. It's difficult. If I have to go by all the endorsements, then I will proceed in that basis.
Impossible.
I will proceed in that basis.
5 matters in a day?
I will proceed in that basis.
Not possible.
I think that much I can expect.
The situation totally changed, my lord. Lots of words appreciate. When my lord joined in the bar and today. What can be done?
Then I have to follow, I have to look at the back sheet first.
This case, had it not been said to my lord that I am not served, my lord will rely on me.
No, I am not telling you in this matter, but today just
Advocates.
if I have to check all those, then I will proceed in that manner.
I can serve and come back, my lord.
Mr. Basu, who is the learned advocate for the caveator? Anirban Ghosh.
Anirban, my lord. Anirban. I know him.
You know him?
I know. I'll inform him, your lordship.
Inform him.
No, I'll serve and inform.
The Mr. Basu, learned advocate, appearing for the petitioner, in his usual Pegason. Yes.
44 to 47 matters the same.
42 and 47, same thing.
44, 40, 45, 46 and 47. 4 suits.
44,
45, 46 and 47.
44, 45, 46, 47, same order. Same advocate for the caveator. All right.
43. My lord, the earlier file has already been.
Yes.
My lord, although all the application which has been filed in earlier CO, my lord, I have annexed in my present CO, my lord. All these things. All right. 7 except, my lord. My lord, if your lordship kindly wish to see the order 6 rule 17 petition, which is at page, my lord.
Order 6 rule 17 application is this application. It is been
This is my lord first CO. Even so, yes, my lord, I have annexed in this also. Yes, yes.
You have annexed. Yes. So
My lord,
I am proceeding on the basis of this.
Yes.
Which page?
My lord, kindly comes to page 40.
And have you annexed the impugned order in order 6 rule 17 here?
Yes,
No.
yes. Oh, yes.
Where is that page?
My lord, page 49 is my application under 6 and order 6 rule 17.
Yes.
And my lord, the order is at page 58, my lord. It was rejected on my lord 10/9/2024. Only I prayed for my lord amendment as regards to the written statement filed in paragraph 20, my lord. That is at page 41 of this running page.
Where is the order rejecting the application for amendment?
Page 58.
58.
Yes, my lord. Page 58. The rejection was on 2 grounds. First, my lord, the petitioner now before your lordship is the bank. It has been taken that the AGM has no power to file an application under order 6 rule 17, and subsequently it has been stated by the learned judge that since PW has been closed at this stage, it cannot be allowed.
No, you are the defendant.
I am the defendant number 6 in the
defendant number 6.
Yes.
page 50 is the necessary correction which I sought for in my application under order 6 rule 17.
So assistant general manager is not the sixth defendant.
My lord,
That is the ground on which.
my lord, it is the interstate dispute between the bank, my lord. My lord, after my lord change of the my lord managers in different bank, my lord. Now the AGM, my lord, take charge of this, my lord, cooperative bank. My lord.
So, but you have not stated that in the affidavit portion.
No, my lord, that has not been specified. It's true, my lord.
Where is your written statement?
My written statement is at page, my lord, page. My lord. Page 36, running page 36.
So paragraph 21, this amendment.
Only below, only in respect of the amount they have received through cash, and it, instead of cash, it will be below check below.
The amount also you are changing.
Amount below 2,53,000, and it will be below page 50, 2,45,500.
petition application. একটা ডেকে দিই তারপরে।
49. For the petition.
Yes,
My lord, this is a suit for declaration of possession and partition.
please use the microphone.
My lord, a suit for declaration of possession and partition. I am the plaintiff.
What is the order impugned?
My lord, page 25, my lord. The ad interim injunction was granted on 8 April 2025. My lord, as per the provisions of CPC, Order 39, Rule 3A, it is required to be served upon the other side. But my lord, on 9th, that is the very next day, there was a resolution of the bar, so it could not be done. And then 10th was Mahavir Jayanti. My lord, we have effected the
No,
service
if
on
there is a
11th.
resolution of the bar, why this service could not be affected?
My lord,
Service can be affected. Where is the problem in serving that?
my lord, since the staffs were not cooperating, it could not be done, my lord. That is the most ironical part, my lord. The thing is, on the very next day is Mahavir Jayanti. It was national holiday. It could not be done. We have it done on 11th. But the thing is, the concerned clerk has sworn on affidavit that it has been done on 10th. That is on the date of Mahavir Jayanti. My lord, there is no doubt about it. It was wrong on the part of the clerk. But simplicity on that ground, my lord, the ad interim injunction was vacated.
Have you served upon them? No.
We have served it on 11th, my lord. But since the affidavit was on the day of 10th, that is the day before on 11th, actual service, the interim order was vacated.
So now, I think it's better I can direct, if you have served.
It has been served, my lord.
To dispose of the injunction application, I think it's better. Otherwise, they have to serve, then they have to come.
My lord, whatever falls to your lordship.
I think it's better that
I leave
I'm
it to your
directing by the order impugned, because they have not yet appeared. They have to be given a time to file written objection. How can I now fix the time limit?
True. Grateful, Your Lordship.
Next.
50, but I'm appearing for the petitioner. There's a caveat I've served.
Caveat you have served?
Yes, man.
Who is the learned advocate for the caveator?
This is my affidavit of service.
Yes. Yes.
This is the impugned order is an order allowing an amendment application. This is a third amendment application. After, my lord, issues have been framed, peremptory hearing is, my lord, fixed. Repeated adjournments are taken for the peremptory hearing, and this application is filed.
So trial has not yet commenced.
Not yet commenced. I'll accept. The borderline case, but the issue is this, my lord. The documents they wish to disclose by way of this amendment application were available with them at the time of the prior amendment application. 3 months before filing that prior amendment application in another suit, where I am the plaintiff and they are the defendants, they had filed those same documents with the
Pre-trial amendments courts are
only
very
time to
liberal.
delay this.
You will be getting your chance to file written statement. This application under Article 227
294.
Lord, and Mr. Banerjee is, Tudiman Banerjee is leading in this matter, my lord. I am praying for a short passover. My lord.
An accommodation has been prayed for on the ground of the learned. Yes.
Lord,
Extension of interim order.
no, Lord.
Application is for
Application is for Lord passing an interim order, Lord, because the
passing an interim order.
yes,
The caption, oh, application for why?
Lord, this civil division has been filed, Lord, challenging an order passed in on 19/12/2023.
So passing an interim order, it cannot be done in this way.
If your lordship kindly allows me to serve, even then we can come back and we can have this matter heard out, Lord. Because this matter arises out of an application under section 24 of the Hindu Marriage Act, Lord. And in the meantime, the petitioner has retired from service, Lord. And the entire scenario has changed thereafter, Lord.
Then you have to apply before the learned trial judge, bringing on record these facts.
Lord,
This cannot be subsequent events. How can that those be taken note of in an application under Article 227?
I'm stating, Lord, just these facts has been stated in the affidavit of assets, Lord. These are already there on the just the month before he retires, the affidavit of assets was filed, and thereafter the order was
stage of the matrimonial suit.
The written statement was filed, and they have taken out an application for execution of the order, Lord. 28A has been filed.
25,000. What were you doing, Mr. Mukherjee, when you were employed?
Lord, he was a officer in the defense service, Lord.
What was his monthly income, salary?
1 lakh, Lord.
25,000.
And after retirement, after retirement, he is now getting 50,000.
Maybe
50,000.
Maybe, but you have some purpose there. 1 lakh. When did you retire?
31st of December 2023.
31st of December 2023.
Yes.
So after the impugned order was passed, Mr. Mukherjee, then you have to apply for modification
But
of
at the time of hearing, Lord, in the affidavit of assets, we have stated all these things.
At that time, you were in service. So there is no infirmity in the order impugned. If you want, I can give you only liberty to approach. You can then withdraw this, file an application. Otherwise, there is nothing wrong in this. 1,25,000.
Lord, we have mentioned all these matters before the learned trial judge, Lord.
You could not have, Mr. Mukherjee, because at that point of time, you were in service. You were in service.
But we have, by an application, we have stated that we are retiring in the month of December. Just kindly see when the order was passed. Just 10 days before he retires, Lord.
Maybe.
Just 10 days before he retires.
Have you disclosed what was the amount you have received on account of retirement benefits?
Retirement at that point of
yes,
time.
Yes, now you have. If you want those facts to come in, Mr. Mukherjee, these facts also have to come in.
That we can disclose, Lord.
So you approach the learned trial judge, disclose all your stand there.
That we can disclose.
Yes. As it is, there is nothing to interfere.
And
as on the basis of the materials which you are on record.
And Lord, if your lordship kindly looks at their affidavit of assets, Lord.
There is no scope to pass an interim order because it was not admitted. So
at least your lordship kindly directly to serve and come back, Lord.
Application will appear in the this court finds that
matter be listed, at least
No,
give
no, no.
some precedence, not so
Yes,
that
yes,
can be taken.
not in this way. Yes, next.
296.
Petition, my lord.
Yes, Mr. Ghosh.
So there are two applications, my lord. Years of OP number 1 and office body number 3.
Yep, Mr. Ghosh on both sides.
Both sides.
How do I address both of you? Yes. What are these applications for?
Application will be short, my lord. Order 6 rule 17 application has been
No, no, this application.
application
and
of
condonation of delay.
Substitution and condonation of delay. Well, already on record in the trial court, but while at the time of
Mr. Ghosh, are you opposing?
Well, if it is there on the trial court, there is nothing to oppose, but they are residing in the same, they are son of the same, they are member of the same family. I cannot say he has said that he has learned it from the learned counsel for the opposite party. It is not totally.
So application for substitution upon the death of the opposite party number 1 and 3.
But they are heirs.
Already on record before the trial court.
All of them are
But
heirs
there's a
of
mistake.
testator.
Petitioner
Heirs
did not-
of testator. But reason is not correct. But Lord, substitution application I am not. Your lordship kind of leaving it to her.
But the main application very
Where the years, where have you stated those?
my lord, in page, my lord. Page
So,
4,
you have
page,
got
4, page 4, my lord.
Yes.
Opposite party member died. Usha Shah wife, Santosh Shah son, Babita Shah daughter, Putki Shah daughter. And 3 died, Anand Shah, Munna Shah, 2 sons. Page 4 of the application.
All right. Opposite party number 1 died on, what is the date of
My lord,
death?
I could not ascertain the date, my lord. My learned senior friend, my lord, at the time of hearings submitted that both OP number 1 to 3 and died, my lord.
Mr. Ghosh, the dates are necessary.
My lord, unless I being the petitioner, I could not ask my learned senior friend, my lord, that is my mistake.
Can 1. Acha, can 2 টাতে লিখুন। Can 2 of 2024
Tentative order passed
So
on
what happens
2nd
there?
April.
The interim order is extended.
Respondent, my lord,
Yes, what is the third application, Mr. Ghosh?
my lord, I am the, oh, come on.
There is no
Two
third
applications. Yes, where is the other?
1 and 2.
3 is also appearing in the list.
There is no
297
three.
Targetta?
No, no, no.
96.
Oh, 296, sorry.
Yes.
Yes.
I am for the respondent, my lord, miss the brief, my lord, because miss the list.
Yes, Mr. Go,
Ah,
Mr. Rai.
He told me what that there's a DA on 15th.
He has not
And
served
today-
your notice, Mr.
My lord, it is appearing after 8 months.
He has informed you after the matter is appearing in the list. Not before that.
It was the clerk. His clerk went to me, his clerk, annual matter is there. So my lord, next week lawsuit keep any day.
Yes, what are these applications?
One is for reimposition of, not extension, reimposition of interim order.
When it expired, Mr. Rai?
The initial,
Long before, my lord.
the initial application was filed, my lord, two applications, my lord will find.
What is CAN 1?
CAN 1 for substitution.
Substitution.
Yes.
Within time.
What happened, my lord, your lordship will find the person who was intended to be substituted, their application was turned down before the court below, which is a challenge before your lordship. Your lordship of the opinion as the property has already transferred kindly on the other occasion, so they are not the necessary party. So substitution as of this is not necessary.
So I'm recording that.
Already transferred the property in favor of the petitioners.
Let it
That
be
is
on.
CAN 1. CAN 1, he is saying that it has become infrastructure. I'm recording that.
In view of the order passed by your lordship in.
Mr. Rai, learned give me, where is that order?
Yes. CAN 3 for imposition.
CAN 3? CAN 3 ta kotha hai? So CAN 2 also has become infructuous.
That is for.
So according to you, it has to be reimposed. So CAN 2 I am
It is
discussing.
not, this honorable court is of the opinion.
Yes, CAN 2. CAN 2 of 2024, comma
2024.
Before 1 year. For 14 months.
After that matter was appeared before my Lord Justice Vasu. And his lordship of the opinion, he did not to mention the matter for extension. It will be, when it will be taken up, it will be considered.
So 14 months is over.
I'm fixing this matter under the heading.
Eight.
298, yes.
Serial number যেটা বললে, এটা হচ্ছে-
Restoration. Yes, yes.
This matter was dismissed for default on 27/9, your lordship. I have stated in my paragraph 2 and 3. I could not make my appearance due to illness and it was dismissed. So I'm praying for restoration here. Let the main matter be heard.
Which is the order under challenge? 30th of January.
No, lordship. Order under challenge is 27/9/2024. None appears on petition PL non-account.
No, that is for restoration. What is the challenge in the, what happened in the appeal?
No, your lordship, this is an order. This is a revision application for occupational charges.
Yes, what happened? Who are you in the appeal?
In the appeal, I'm the respondent. The thing is this, without any occupational charge, stay was admitted. That's why we have come here. Without any occupational stay was admitted. This is the civil revision application. On that day, none appeared and the matter was dismissed for default. An eviction order was.
Where is the order dated 16th of August 2018? Sir, the stay order was passed in 2018. So you have paid for occupation charges in 2024. So it's better that the appeal is disposed of.
Lordship,
You don't want the appeal to be disposed of.
I want the appeal to, but we have prayed for an occupation. There should be stay. Lordship, we have already filed a execution application. As there is stay, so
Sir, you are the decree holder. So you will be benefited. You want the occupation charges, not the possession.
No, Lordship, not on that. The thing is this, the landed court has passed an order that the appeal should be heard. We are on the.
So what happened on 2nd of March 2024?
Lordship,
Today's the appeal. What happened on 2nd of March 2024?
Lordship, that I have not today's fixed application, your Lordship. I have not got in the brief there. Then I'll correct it. Let this matter be restored. We'll fix that date. I'll make the hearing.
No, sir.
I know.
I follow a different practice. I take up the main matter at the time of restoration.
Then Lordship, kindly fix it tomorrow. I'll be prepared. Kindly fix it.
The learned advocate. Adjourned. 299.
299, my lord, I am appearing on behalf of the petitioner, my lord. This is an application for restoration, my lord.
Yes.
This is the affidavit of service.
Yes.
My lord, if your lordship kindly take up the main matter in the next week, my lord.
Yes.
Rejection of counterclaim.
Yes, sir.
Is it a revisable order?
Rejection of counterclaim, my lord, against that order I have.
Is it a revisable order?
At the time of admission of counterclaim.
No, it says rejected.
Not the merits.
Exclusion of counterclaim from the written statement.
Under what provision it is being rejected? Where is the provision? Under the Code of Civil Procedure for rejection of that counterclaim. 6. It has not been excluded, rejected, meaning thereby he cannot also file a suit.
Why, my lord? That's why.
Then let's
see too. On the
Mr. Mukherjee, then it cannot be a revisable order.
That's why. The court has correctly
done. There are two things. If it is excluded, he can file a separate suit. That is one thing. If it is rejected, it cannot be.
It decides that it undecided, remains undecided. That is your lordship. Court has noticed that on the ground of Benamdar, he has filed a suit where Order 7 Rule 11 has been allowed on my instance. So it's a de novo thing. In my suit for eviction of licensee, he wants to insert this by way of counterclaim. The court noticed that this claim in a substantive suit, Order 7 Rule 11, your claim goes already.
No, then Mr. Mukherjee, there are two things. Is it Order 7 Rule 11?
Order 7 Rule 11 in this suit.
No.
No, in the present.
Mr. Mukherjee, I am asking you under what provision this order was passed? Order counterclaim is a suit.
Yes.
So rejection under what provision? I'm asking you. I appreciate his claim rejected, order 7 rule 11.
Exclusion is being done. He has not been
No.
permitted. I'm just, just kindly text the impugned order once.
Yes.
Maybe the language has been couched in that fashion, under Article 227, if the ultimate decision is there, your lordship can supply the reasons. Kindly see the last paragraph of the order before proceeding to expedite the matter.
Plaintiff's petition is your petition. Where is your application? Please show me your application.
Mala page 78 annexure I.
My prayer is for exclusion.
Yes, exclusion is order 8 rule 6C.
Yes.
What does it say? Yes, please see this. Not in this suit, but in an independent suit. If that is so, it has to be excluded, cannot be rejected.
Kindly clarify that. Kindly clarify that. My prayer was also there.
Yes, what do you say?
Mala, can it be taken up next day, my lord?
Why?
Well, today I'm not ready, my lord.
Restoration application, exclusion.
Can we take up this matter next week? Now?
No restoration then. After some argument, Mr. State Learned Advocate appearing.
May I file affidavit of service, my lord? Sanjeev Seth, advocate on the court. Affidavit of service.
Yes. None appears for the petition.
Malad, this is for extension of interim order, but interim order expired in December. Whether this application or reimposition application has to file, or I will file a supplementary affidavit, my lord. As is condition.
Are you opposing the prayer for interim order?
Fix the date for final hearing, my lord.
And then one.
What is the impugned order?
Impugned order, my lord, for hearing of the application for for hearing of analogous hearing of probate case as also as partition suit. And initially interim order was passed. My lord, Mr. Justice Champa Sarkar, my lord, then it is extended by Justice Biswajit Basu.
This is not adjudicating order at this point.
Not adjudicating order.
Transfer the matters order, my lord. Let's switch for earlier.
What is the order impugned? What is the date of the order?
My lord.
21st of December 2022. Yes, Mr. Chakraborty, what order you are challenging?
And challenging, my lord, that the analogous hearing of the both partition suit and the probate case, my lord.
Yes, where is the
But then-
difficulty?
Yes, that is we want, not challenging. We want hearing of the both case at the time.
Yes, that is being done. That is
not done, my lord. It's such as
So
such.
that is the order for hearing of the petition analogously with the case number such and such.
But they have to, my lord, not done.
Code only here, my lord. Probate case, partition case has not been touched, my lord. So that I have come here against that order.
But you have challenged this order, that is a different thing altogether. That is a subsequent cause of action. But this order, nothing to challenge this.
Malad, we want hearing of the partition suit and the probate case at a time, Malad.
So that is the order.
But then lawsuit recorded, there's an order to have both the case at a time.
We shall not stand on.
Then nothing remains, Malad. Then question of
That day, my lord. Next day it was rejected. My lord, that's order.
Malad is coming.
It's been rejected. Where is that? Where is that? By which order it was rejected?
Supplement affidavit.
February 9, 2023, my lord.
I have
February-
supplement affidavit, my lord. Supplement affidavit is
9 February 2023, my lord. It was on order number 19. my lord.
my lord, I have filed supplement.
Order number 19. Malad, then order number 19, 9 February. Oh. Council for the partition is
Yes, then you have to challenge this order of 9th of February. You have not challenged that.
in the original application, Malad. Or
The
CO.
original application, you have challenged the order dated 21st of December 2022 only.
Enter order sheet annexed and Malad here. Then that will be corrected. My lawsuit get liberty to correct it.
Will be granted to correct.
Order sheet is annexed, my lord.
Yes, what is the difficulty if both the suits are being heard analogously?
We are five probate case, my lord, of the same property, my lord. If we win, then their case will be infructuous.
What will happen? No. Probate is, what is the fact? The,
Yes, probate case, Malad, after filing.
Filed the suit for partition.
so, the heirs of the testator,
Yes.
they have filed the suit for partition.
Yes.
And one of the heirs claims that he has got the property by Mr. Chakravarti, then the probate has to be decided first.
And then let
If the probate is
and let the case be heard analogously and the judgment be passed one by one after. First probate case may be judgment.
Supreme Court category stated.
Where probate case
Supreme Court category stated that both the.
Give me the judgment.
My hands, my lord. Adjourn this, but I said so.
Ashwin, this can 1 of 2025. This is an application for extension of interim order. First up, can disposed of. Next.
302. I appear for the.
Yes.
Restoration application. The main application is for one expeditious disposal of injunction application on contested hearing.
At item number 303, I'm led by Mr. Dheeraj Trivedi, my lord. Can application 1 of 2024 is for substitution of opposite party number 1, my lord.
This is an application
For substitution, my lord.
within time or out of
Within
time?
time.
Within time before the
Fine.
registrar logima. Since the asun. Necessary orders. Just a paragraph.
04.
Worship, for the petitioner in this matter. For
Yes.
extension of interim order, your lordship.
Extension of interim order. Have you served the copy of this
Yes,
application?
yes, your lordship. This is my affidavit of service
Upon whom have you served?
to the all respondents.
Where is the written statement? Where is the application for amendment?
Your lordship, that has not been annexed in this CAN application, your lordship.
No, in the civil division application.
Your lordship, I beg pardon before your lordship because this matter I'm led by Mrs. Gargi Roy is out of station and the application is with him, your lordship. Page. You should see.
Where is the original written statement? You have not annexed the original written statement. Yes, what is your objection with regard to the amendment?
Your lordship, initially it was the trial was started. The
Yes,
cross
That
examination.
is not an absolute embargo. If the proposed amendments are necessary for the purpose of determining, it can be allowed even after the commencement of trial.
Your lordship, on the earlier occasion, Honorable Justice Vishwajit Basho has passed this order.
Please satisfy me.
Your
Now you are
lordship,
before a different judge. Now you are before a different judge. So please satisfy me.
Your lordship, my
So
file.
mere commencement of trial is not an absolute embargo. Even if the trial has commenced, if the facts are necessary for the purpose of determining, amendment can be allowed. Those are the line of decisions of the Honorable Supreme Court. I think one of the recent decisions of 2024.
Your lordship, I pray for 1 week adjournment and so that.
Yes.
For petitioner.
Yes.
Application for extension of interim order, lordship.
You served upon the other side.
I have served upon the other side, the main application, your lordship.
But
Can has not been served.
Yes, if you please serve upon them, otherwise.
I have submitted, filed the affidavit service of the main application.
Main application, but you have to serve upon this also because they will not know.
Lordship, I will serve, lordship.
Petitioner
It
is
was
directly
in the month of November, your lordship, 2024.
this application.
Yes.
What is the main civil division application?
Rejection of order 7 renewable application. Very cryptic order. Kindly comes to the impugned order, lordship.
Sir Haldar, if the suit is expedited, you will be
Lordship, it's absolutely barred. This is a lordship. Kindly comes to the plain, your lordship.
absolutely barred. What is the bar?
Limitation, lordship. Agreement was executed in 2011. Subsequently, I have cancelled the agreement in 2016. In 2021, the plaintiff filed a suit being a developer against the landlord. Pretending upon paying for a decree of declaration, he is paying for specific purpose of contract. In 2021, lordship, no prayer, no paragraph, no dealing with the period of limitation, lordship, kindly comes to the cause of action page, lordship.
Petitioner. Call the next matter.
306.
I am appearing on behalf of the opposite party.
Yes. Have you served?
I am the opposite party, my lord.
So you are the opposite party.
My lord.
There is no one
They were
for the petitioner.
My lord, date may be fixed. I will intimate, my lord. My lord, don't make it goes down, my lord. Then I will be in trouble because there is a stay. I am suffering.
There is a stay.
Yeah, my lord. As per the letter. Suit property is different, my lord. And my lord, Section 10 application in respect of the probate case, which is filed subsequently to the suit of partition suit. And my lord, the property is different. Plot numbers are different.
None appears for the petitioner. First up, no.
Mala, kindly fix a date.
Of the application.
Mala, kindly fix a date, Milord. Mala, I will intimate, Milord, because otherwise I will suffer. Mala.
Yes, yes. Not before vacation, it's not possible.
Then,
Yes,
Mala, can then vacate the stay, Milord.
He has been vacated. Extension of interim order. I have not extended that.
I'm good.
My lord, I am.
This is an application for extension of interim order.
I appear for the petitioners, my lord.
Yes.
This is an application for extension of interim order.
Have you served?
I have served twice. I have
the application.
Yes, even the application. This is my affidavit of service.
Yes.
The initial order was passed on.
What is the impugned order?
The impugned order, my order 1 Rule 10 application was rejected. It was recalled and then suo moto the hearing was suo moto it was undertaken and my application was rejected when in fact it was allowed on the earlier occasion. This order
Service file 308.
I'm for the petition, Madam, led by Mr. Tanmay Mukherjee. He is not here today, but my lord, the lower court date is fixed on 20th May. The
Yes,
extension for the-
extension of interim order. I have not, but not record, Lord. I am not, whatever it is.
Madam,
Yes, sir.
by the well, may I file the
And
application?
disposed of. Yes.
Next. My lord, I appear for the petitioner.
My lord, I'm appearing for the opposite
My lord,
party.
the issue was whether, my lord, filing of a suit for eviction would act as a bar from, my lord, relying upon the arbitration clause which is there in the agreement. Plaintiff suit for specific
My lord,
performance on the basis of an agreement, written agreement. Plaintiff case is that it was novated. My lord, my lord, relied upon the arbitration agreement in the written agreement and prayed for, my lord, dismissal of the suit in view of that, my lord, existence of the arbitration agreement. It got rejected because, my lord, the learned court held I have filed a suit for eviction subsequently, therefore I have given a go-by to the arbitration agreement. This was, my lord, the finding. Now, my lord, when this civil revision application was moved, Justice Basu was pleased to pass an interim order staying all further proceedings. My lord, the order is of 24th of September 2024. I have filed this application for extension within the time, my lord, before December 20.
No, what is the impugned order?
My lord, by the impugned order, my application has been dismissed. My application was for, my lord, dismissal of the suit and referring the parties to the, my lord, arbitration.
Dismissal of what suit?
His plaintiff suit. For specific
You have filed a
performance.
suit for eviction.
I filed a suit for eviction which is subsequent. Plaintiff suit for specific performance of an agreement which is as per plaintiff case written agreement novated by oral agreement. I filed the application relying upon the agreement, the arbitration clause.
Both of you are relying upon the self-same agreement.
He is relying upon a novated agreement.
So Dr. Dilane trial judge was right.
No, he is relying upon a my lord agreement which has been novated. That is his plaintiff case.
But the fact remains, both of you are relying upon the
Plaintiff is no longer relying upon the written agreement. The moment plaintiff case is, my lord, novation, plaintiff abandons the written agreement. That is, my lord, the plaintiff case.
Yes.
That so, my lord, he proceeds on the premise, plaintiff proceeds on the premise.
Your eviction is dependent on that agreement.
So, my lord, both can go to arbitration.
Both can also come to the
No, my lord, if it is
civil court
if it
also.
is covered, my lord, if it is covered by the agreement.
Yes, so it has to be considered.
My lord, kindly, my lord, it is.
Dotto,
my lord, I had a tough time convincing Justice Basu, my lord, to admit and, my lord, pass an order.
You have a very tough time. You will be having a very tough time. Since you have filed a civil suit for eviction, you have waived your right.
My lord, I would like to rely on.
Waived your right.
I would like to rely upon, my lord, some authorities. What is the power of court? My lord, referring court. What is the power of a referring court when the court receives an application under 5.8? My lord, only to see whether, my lord, the arbitration agreement exists or not.
All right, I will hear both of you. Let me extend the interim order. Is appearing, no,
I'm appearing for the opposite party.
yes, he's appearing. So, application disposed of. Next.
310.
My lord, I am for the.
Yes.
My lord, this application, my lord, I have filed because, my lord, before that, my lord, your lordship is the revisional.
Extension of interim order.
No, my lord, there was no interim order. By this time, my lord, this was actually challenged because the learned court below has allowed an application for handwriting expert. We had challenged that, my lord, before your lordship first. My lord, the matter could
So have
not
you
be
solved,
heard.
you have solved the civil division application?
No, my lord, that there is no order, my lord. It has not been, never been heard. That is the basis.
So then why, this is for what?
My lord, this,
Why have you
my
filed
lord,
this
the expert,
application?
my lord, the expert opinion has been already given.
Unless it is admitted, there is no scope for any application.
My lord, let's see.
So this was appearing under what head?
My lord, motion. This was appearing under the head motion. My lord, again, my lord, we have to file a supplementary affidavit.
Why
to this.
supplementary?
Because, my lord, the
Then
order.
civil division application contains the prayer.
No, my lord, the main civil division application contains the prayer
Not for interim order.
particular for the order which we have challenged.
Yes, a stay of operation of the interim, there, that is there. Yes,
Well,
call the next matter.
My lord, in the meantime, my lord, my already.
But in the meantime, nothing. Can disposed of.
They can be.
Menta thakbe, menta.
They can be there, my lord.
No.
That is what I want. Because
And is nothing, I have said that. Since the without the civil division application being taken up, there is no scope to pass an interim order. For that reasons, in the light of,
my lord, we have to
in
file
view
again,
thereof,
my lord,
your
a supplementary affidavit. Otherwise, my lord, this will not be heard.
that, yes, call the next matter.
311.
Appear for the review application.
Respondent 1 and 2.
Yes.
Now, this was a case note where the employees of Indian Association of Cultivation of Science at the time of implementation of the 7th Pay Commission's recommendation were put back to the stage.
Majumdar appeal, I think its scope is larger.
Your lordship was persuaded to pass this order, partially protecting my client's interest insofar as recovery is concerned. Insofar as prospective fixation is concerned, your lordship held that since the 6th Pay Commission recommendation was not approved by the ministry, therefore no right has accrued in favor of the writ petitioner.
So, Mr. Majumdar, it has to be hard.
No,
So, if you want, I can post it after the vacations because
I have got the RTI reply where from it appears that the 6th Pay Commission recommendation was approved. Now, paragraph 30.
You can take that point in the appeal, Mr. Majumdar.
It's a document,
better.
it's a fact, it's a discovery of new fact, which may turn have an impression.
I'm not saying you cannot file a review, but it's better if you have, because the scope will be wider.
All other issues have been decided by your lordship's court. The sole ground on which your lordship has been persuaded to hold this issue against my client is the non-approval of this
Then I'm taking
recommendation.
it after the vacation.
Not or if they so want to use an opposition to this, they can come back.
So there is a delay.
No, there's the sole ground. Please come to page 28 and 31.
Where is the scope to file opposition, Mr. Majumdar?
If they want to say that, no, we have not approved, that's all, because I have relied upon an RTI reply.
RTI reply.
RTI query and the reply.
So you can take instructions on that. I'm
Yes.
not directing you to file any formal opposition to that. List this matter under the call the next matter. No, this 311 and 12, same. 311, 12, same order. Next.
Same that. 12, I appear on 12, my lord, I appear on behalf of the petitioner, my lord.
Then the 13.
No, 12, 12.
12, yes.
Review application, my lord. Only,
Yes.
only turn up cross examination to defender number 1. Ground number 9, ground number 9 and 10 and 12. Only cross.
No, same order নয় বলছে ঠিক আছে
Only my review application is allowed.
Where is Mr. Kundu? Bring him because
Only reflected, not reflected, my lord. Cross examination.
Yes.
And led by him. My lord, this is a suit for compensation on account of false accusation.
All right,
By the
please,
plaintiff.
please ask Mr.
My lord,
Kundu to appear because
my lord,
review by change of advocate.
No,
Yes.
my lord, I appear.
He
I do record, my lord.
Maybe, but Arvind counsel was Mr. Kundu.
Tomorrow, my lord.
Adjourn, not
Tomorrow.
today.
Not today.
Yes, next.
13.
Yes. 330.
Restoration application. Restoration application.
Yes.
Opposite party, husband. The opposite party.
You are opposing the prayer for restoration.
Not
What is the main civil division application for?
suit for আপনি বলুন আপনি
স্যার একটা মানি শুট করেছেন আমার হাজবেন্ড এবং ওনার এল্ডার ব্রাদার আমার এগেনস্টে 45 লাখ টাকা ক্লেম করে তো সেটার অর্ডারের এগেনস্টে অর্ডার নাম্বার 37 যেটা পাস্ট হয়েছে 19/12/2024
I have filed the caveat. I have filed the caveat for the opposite party.
In this matter?
This matter, yes, my lord. And she has served me. And I, my lord, I have my, I am not opposing my that friend. One thing, my lord, this gentle lady has filed 498 cases.
All right.
My lord, 2 FIR was lost in 2 police stations regarding several identical cause of action. Different stories. And that is why both the cases she has lost.
স্যার এক সেকেন্ড
And that is why money shoot was filed alleging defamation. And the thing was that she has taken a plea that on that particular date, she went to Supreme Court.
All right, I am allowing the restoration.
My lord, I have objection, my lord, because 20th May, my lord, is the next date. 20th May. She is killing time right from the 9th.
I'm only allowing the restoration application. Also. 314, yes.
And for the opposite party in the application. My lord, revisional application was mine. My lord has passed an order directing expeditious disposal. My lord, recalling has been filed. My lord,
I am for the opposite party applicant, your lordship.
You are for the,
Opposite
who is for the petitioner?
my lord, I was petitioner in the revisional application.
This application is your application.
Yes.
Yes.
Filed by the opposite party.
Yes.
Our sole contention, your lordship, is that in the year 2027, while your lordship being an learned advocate had appeared for the same petitioner arising out of the same trial court proceeding.
I was not aware. Anyways, my lord, this doesn't affect to merit of the proceedings. My lord,
That's why
kindly
you have-
appreciates, my lord.
That's why you have filed.
This
for-
doesn't affect anything.
Mr. Chok.
Lord, I do not dispute my learned friend's contention. It was there, my lord. But is he objecting really to the order of expeditious?
Just file an application, Mr. Chatterjee, by saying this. That shows that he is opposing.
The next date is fixed tomorrow, your lordship.
My lord, I am for the petition.
Yes. Yes, first time.
No, my lord. Kindly come, my lord. Order dated 28 November 2024. My lord, specifically the respondent said that they will file the affidavit in compliance.
All right.
But till date, my lord, it is not. My lord,
Look
a
at
rule maybe you should, my lord, petitioner suffer from.
One prayer, Lord. Item number to bol Lord, item number 74, Lord. Lord, section 14 order.
74.
74, Lord, my Lord, called up to 51. Lord, there is some urgency. I tell you, Lord, what, Lord, section 14 order.
I have some limitations, Mr.
Lord,
Chakravarti.
tomorrow,
You can proceed as far as you want.
Okay, so tomorrow. That is same time. I tell you what happens.
Item number
74, Lord, the section 14 order. The CGM appointed.
you want.
CGM appointed a lawyer to the bank.
What do you want?
Tomorrow, can I take a view position?
Let me see what happens tomorrow.
You have first order in your favor.
Let me see what happens tomorrow.
Some precedent, not some precedent.
Come tomorrow, let me see what happens.